Welcome, everybody. I'm going to convene the meeting of the September 23rd Joint Committee on Special Claims Against the State this morning. We're just a few minutes late, but we are all here now and we are ready to go. I will ask our legislative researcher, Merle, to call roll. We do have a couple folks who may be joining us late, but they'll be here.
Senator Dietrich.
Present.
Representative Ralph.
Present.
Senator Haley. Senator
shortly.
Senator Straub. She did indicate she may be running late, ma'am. Representative Humphreys. Representative Miller. Representative Samsel.
Here.
Ma'am, you do have a quorum, and just to let you know, the live feed is running right now, so we are broadcasting.
Very good. Thank you very much, and thank you all for being here with us today. Our very first claim is claim number 7140, which is a carryover claim. So we'll wait for the dial-in. Takes a minute to connect.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt.
Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There have been too many failures.
Don't take it personally.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt.
Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt. For visitation, press 3.
Please dial the extension number. Press the star key to start over. We will now connect you.
Hello, this is UNT Marines, VDCS. How can I help you?
Hi, this is Meredith Fry with the Joint Committee on Claims Against the State. We are trying to reach Mr. Gillespie.
He is right here with me. I am moving the phone slightly closer to him so he can talk to you.
Okay, thank you.
You want to say something? Good morning, ma'am.
Good morning. Mr. Gillespie?
Yes.
This is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing the appeal of your claim to the KDOC. It's been previously denied by the department. You are on speakerphone with the committee. Excuse me. The committee has been provided all of the documentation of your claim for our review, including your description of the loss. So I'm going to give you the chance to tell the committee anything else you would like us to know about that claim. Then when you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. And when that's completed, the committee is going to take time to consider the claim, and then our written decision will be provided to you within 21 days following the date of that decision. Does that make sense to you? Do you understand?
Yep.
Very good. So please tell us what you want us to know in support of your claim.
What claim are we doing first? We're doing both of them.
We're doing claim number 7140. It's a property loss of $121.60.
Okay. That scenario, what happened was a CO came into my room to shake me down. Well, when he came in and shook me down, he seen some food in a canteen bag, and he said one of the things wasn't on my canteen list. Well, in Ellsworth, they have a lot of fundraisers from the chaplain, JC's, reaching out from within, and all those fundraisers, they don't have access to look up their what inmates have bought on their computer. So we have to provide receipts for what we've actually bought through those fundraisers. So when he seen that there was chaplain cuisine sausages in there, it wasn't on my canteen sheet, he took the whole bag, and he said that was something that the DR board should have to sort out for themselves. So whenever I sorted all that out, I showed them receipts and everything, and then I turned around and fought it, and I still got convicted of it, but they kept bouncing me back and forth between the DR office to my unit team and my unit team to call EAI to try to get my food. And they never end up giving me no food. And then whenever I went to restriction on that and I filed a property claim, they quit altogether even trying to work with me. And I tried proving receipts whenever they shook me down to keep from even having it go to the disciplinary board. And ks.gov wouldn't even give me the time to let me show them the receipts for it.
Very good. Thank you, Mr. Gillespie. We're going to have a response now from Department of Corrections attorney. Would you introduce yourself and?
Okay.
Chairman Dietrich.
Oh, I thought you had tested it before I got up here. I apologize. KAR 4416-105 and IMPP 01118 provide that inmates own property at their own risk, and claims shall not be paid unless the loss directly resulted from staff negligence. In addition, KAR 445111 provides that items that are subject to a rule violation or contraband shall be seized, and the inmate forfeits all rights to them. And then we do have a prison rule prohibiting dealing and trading of property among inmates. Mr. Gillespie was found guilty of dealing and trading, and he's not entitled to compensation for property that he possessed in violation of regulations. Items for which purchase history was established were designated to be returned to him. His claimed loss is unsubstantiated, and it is arguably not the direct result of staff negligence, but a consequence of commingling his purchased property with his contraband. However, the department is unable to locate any documentation indicating that any items were returned to him as they were intended to be by the disciplinary hearing officer. Based on the foregoing, the department is recommending that the claim be approved, but in the reduced amount of $60.80.
what?
I'm sorry?
You said to approve what?
Approve the claim in the amount of $60.80, which is basically half.
That's better than nothing.
Thank you, Mr. Gillespie. Do you have any other comments for us? So the recommendation is to,
Well, the only thing I have to say really is even though if they come in and take, let's say they take 100 items in a shakedown, dealing with a dealing and trading scenario. If they come in and take 100 items, and I've proved receipts for 99 of them, I'm still guilty of the dealing and trading. I'm not arguing the fact of the dealing and trading. I'm just arguing the fact of the things that I've paid for. That's what I'm arguing.
yes. Thank you. Thank
So
you.
I mean, even if I can prove everything but that one thing, I'm still guilty of the dealing and trading. But just because I get convicted of the dealing and trading, that shouldn't be reason enough to keep everything that I have paid for.
Right, and
That's all I'm arguing.
that is not what the department's arguing.
Thank you, Mr. Gillespie. Appreciate that.
Yep.
Any other questions or anything from the committee? Representative Miller.
Thank you, Madam Chair. Mr. Gillespie,
Yeah.
were any of the items ever returned to you?
No, that's like I said, the DR board act like they were going to work with me, and they said to go ahead and get back what I proved receipts for.
They've already conceded,
then-
they've already conceded they don't have a record of returning it. I just want to confirm directly with you, nothing was
No.
returned, yes or no?
No, they never returned
All
anything
right,
to me.
my next question is, you mentioned that there were some items in your possession that you didn't have receipts for, and you indicated circumstances that you come by those legitimately, but you don't have a receipt. Do you remember that testimony? Like for fundraisers?
Yeah, that's what the fundraisers I had to turn around and send Form 9s to them to turn around and get the receipts for. That's like the undated 5 sausage in the 24 pack of Dr. Pepper. That's from the Chaplain Cuisine. So I had to wait for them to print off receipts for backdated stuff because I never realized that I should have had to keep receipts like that on food and everything. 'Cause I never really had to worry about it. Now I keep receipts on everything for that situation, so I don't have to worry about it.
Thank you.
Yep.
Were all the items that were seized items that you came by in a legitimate process?
Yes.
You were not trading and dealing anything?
Everything on that property claim I have paid for.
Well, you may have paid for it, but did you pay for it in a legitimate process?
With canteen receipts, yes.
Madam Chair, I would move approval of the claim.
In a recommended amount of $60.80 or?
No, in the amount of the claim.
May I clarify?
Yes?
I think there's a little bit of equivocation. I think everything in the claim is accounted for with canteen history and purchase receipts. And I don't think what he has said is that there was nothing there that he couldn't provide a receipt for that he didn't purchase legitimately. What he said was staff doesn't have immediate access. The staff who searches the cell doesn't have computer access to the chaplain's or fundraisers' purchase history. So they found something that didn't match that was apparently from one of those fundraisers, decided everything in the canteen bag was mixed with it, and just grabbed the whole bag and put it in evidence for a disciplinary hearing to be sorted out. At the disciplinary hearing, he was found guilty. The property was separated. Items that he had a purchase history for were designated to be returned to him. But there were other items for which he did not have a purchase history through the canteen or through chaplain's receipts or anything. And he says as much in a grievance, which I have not attached, but he says, yes, there were some items that I didn't purchase, but I should be entitled to get back the things that I did.
But you haven't
And we've-
attached
we've-
that.
No, I haven't.
Move approval of the claim in the amount of the claim.
Is there a second? There's no second on that motion, so do I have a second motion perhaps to approve the claim in the amount recommended of $60.80? Move, do I have a second? Second. All those in favor signify by saying aye.
Aye.
Any opposed? Okay. We will approve that claim in the amount of $60.80. Mr. Gillespie, can you stay on the phone with us? You have a second claim? This is for 85?
Yes.
Yes, it's for 80.
7141.
Yes, $85.57, claim number 7141.
Yes, ma'am.
Can you tell us about that claim?
This This was pretty much the same scenario. It was another shakedown right afterwards by the same officers. And, the only difference on that one is I didn't fight it. I took a plea on that, and I did plead guilty to dealing and trading. I don't know if you have a list of the DR, the disposition, but they have a list on the back, and there's some items on there that I was guilty of buying from somebody else as far as dealing and trading. So I didn't fight that DR, but I proved receipts for them through the DR. And then I took a plea, but they denied me my property claim because they said I took a plea. I took a plea because I was guilty of for having items like, there were some little Debbie cakes and some seasonings and stuff like that I didn't buy from the fundraiser. So I took a plea instead of taking it out and going through all the hearing stuff. But then they denied me my property claim because the same reason that I took the plea for dealing and trading. It's the same thing though. But they just did it to me again right afterwards on the other one.
Thank you, Mr. Gillespie. I'll now hear from the Department of Corrections Attorney Libby Snyder.
Thank you. Mr. Gillespie's present claim is that his cell was searched in March of 2020. He was charged in a disciplinary case, again, with dealing and trading. He was charged based on being in possession of items he had not purchased. On March 17th of 2020, the disciplinary hearing was continued with the notation, offender waiting on receipts. On March 25th of 2020, Mr. Gillespie pled guilty to the charge, and the hearing officer ordered that the evidence be destroyed. 2 weeks later, Mr. Gillespie submitted a facility claim asserting that he had receipts for the food in question. The purchases he listed were dated from March through May of 2019, roughly a year prior to the cell search. He offered no explanation for having pled guilty 2 weeks prior, and the claim was denied, nor did he offer any such explanation in his present claim. Inmates do own property at their own risk, and items that are the subject of a rule violation are contraband. Mr. Gillespie his claimed loss is not the direct result of staff negligence, and he's not entitled to compensation for property that he pled guilty to dealing and trading in violation of prison regulations. So we're recommending that this claim be denied.
Thank you. Mr. Gillespie, do you have any response?
No, not really. I've already said everything I think that would cover it. The only reason I was waiting on receipts, like I said, was the fundraisers. That's not I'm at the mercy of them for them to print off my receipts. That's the only reason the DR board never got the receipts from my fundraisers.
Very good.
But that's why I included them on my property claim whenever I got my disposition. They said to destroy everything. That's what brought the property claim on.
Thank you,
Because
Mr.
they didn't give me a chance to get anything.
Thank you, Mr. Gillespie. Committee, do you have any questions of the claimant? If not, I think we'll move on to our next, because we're running a little bit behind, and we'll group these claims together when we have a little bit of a break. Next is claim number 7200, Mr. Henry Scott.
Over Correctional Facility, this is Paul Wilson. May I help you?
Hi, my name is Meredith with the Joint Committee on Special Claims Against the State. We were trying to reach Mr. Scott.
Yes, ma'am. He's right here. 1 minute, please. Hello?
Mr. Scott.
Yes.
Hello, this is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the state legislature. The committee is hearing the appeal of your claim to KDOC that's been previously denied by the department. And I think it's for $51.22. So the committee, you're on speakerphone with the committee. We can hear you. Hope you can hear us. The committee's been provided all the documentation of your claim for our review, including the description of the loss. So I'm going to give you the chance here in just a minute to tell the committee anything else you would like us to know about that claim. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. When that's completed, the committee is going to take some time to consider your claim, and then our written decision will be provided to you within 21 days following the date of that decision. Do you understand?
Yes, yes, ma'am.
Very good. Would you like now to take a minute and tell us about the claim?
I can barely hear what's going on. Hold on one second. Yeah, okay. Can you repeat that?
Yes. Would you want to tell us now any more details about your claim that you'd like us to know about?
Everything I needed really for you to know, I put in my report. The officer that I spoke with, I got a response back from my unit team saying that that they did an investigation, saying that the officer that they spoke with had no recollection of even touching my property. So I went and spoke to that officer, and he told me nobody ever spoke with him at all.
Very good. I'm going to ask the attorney for the Department of Corrections to present their side of this issue. Go ahead.
Thank
attorney.
you.
All right.
Mr. Scott alleges that on May 16th of 2021, he was moved to segregation. His property was packed by staff, and he states that his chips and cereal were missing when his property was returned to him. He did file a facility claim. The claim response stated that the staff who packed his property had no recollection of touching any of Mr. Scott's canteen items. In his present claim, Mr. Scott alleges that the claim investigator, the facility investigator, did not contact the staff who packed his property. Facility staff responding to the present claim spoke with the claim investigator, who was emphatic that he had contacted the staff mentioned in Mr. Scott's claim, including speaking with 2 Bachmans who were on staff at the time. In addition, the relevant property inventories were provided, and they reflect that Mr. Scott signed for the receipt of his property without noting any discrepancies or noting anything missing. Inmates own property at their own risk, and IMPP 12120 provides that inmates are responsible for noting any discrepancies when signing property inventories. His alleged losses are unsubstantiated because he did not do that, and there is no showing that any alleged loss was the direct result of staff negligence. So we're recommending denial of the claim.
Thank you. Committee, do you have any questions of either the claimant or the attorney? Very good. Thank you, Mr. Scott. We will be back with you with our decision within 21 days. Next, we'll move on to claim number 7160, Patrick Lee.
This is Greg.
Hi, this is Meredith Fry with the Joint Committee on Claims Against the State. We are trying to reach Mr. Lee.
Yes, I have him right here. Go ahead. Hello.
Mr. Lee?
Yes.
Hello, this is Senator Dietrich. I'm chair of the Joint Committee on Claims Against the State. The committee is hearing your appeal of the claim to the Department of Corrections that's been previously denied by the department for the amount of $25,000 for personal injury. You're on speakerphone with the committee, so we've been given all the documentation of your claim for our review, including your description of what happened. I'm going to give you the chance to tell the committee anything else that you want us to know about your claim. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of that issue. When that's completed, the committee is going to take time to consider your claim, and then our written decision will be provided to you within 21 days following the date of that decision. Do you understand?
Yes, ma'am.
Very good. So would you like to describe to us now the details of your claim? We do have all the written documentation, but there may be something more you want to tell us.
Yeah, I noticed on the packet that the unit team gave me this morning, it says that, unsubstantiated evidence or whatever, it says there's no showing that the treatment was received improper. I'm not understanding that because, I was told by the clinic staff that, oh, no, you can't put it there. And, they say that there's no evidence that, there's caused long-term pain to my arm. And I've been to the clinic multiple times about my arm. None here recently, but a few months ago. And, they've told me there's nothing, they don't see there's anything to do about it. and I'm already prescribed KLPs for Tylenol. And I have to dig through the receipts, but ever since I came to prison, I got every sick call receipt that I've, any and every time I've ever been to the clinic in any facility.
Very good. I think now we'll hear from the attorney from the Department of Corrections, and then if there are any questions of the committee, of the claimant, or the department, we can do that then.
Thank you. Mr. Lee's claim is that on September 13th of 2020, he received an annual Depomedrol injection, and he was advised by an LPN that he was never to receive a steroid injection in the arm. He wrote to medical staff to inquire why he had been receiving these injections in the wrong place, and they responded that the injection was given properly. He inquired again and was advised that the injection can be administered in any large muscle, but Mr. Lee finds this to be incorrect, particularly in light of what he was told by nursing staff. He states that he is sure this is why he's been experiencing long-term pain in his upper arm, and he requests compensation. On October 6th of 2020, he filed a facility claim regarding the alleged injury. The facility claim investigator contacted the director of nursing, who advised that the drug manufacturer does not specify the gluteus in their clinical flyer for the medication, and that the injection may be given in the gluteus or deltoid. They explained that in the prison setting, another staff person must be present for any injection to the lower body, so the deltoid may be chosen to avoid delays in completing the injection. The facility response to the claim also noted that Mr. Lee had been seen several times after receiving injections in his arm, and he had not reported any issues with the arm that was used. IMPP 118 says that claims can be paid only where it is established that the loss or damage was caused by the negligence of the state or any agency, officer, or employee thereof. Mr. Lee's alleged injury is unsubstantiated. There's no showing that the treatment he received was improper, and his claim fails to establish that any such injury was the direct result of negligence by the state or any employee thereof. We are recommending denial of the claim.
Thank you. Committee, do you have any questions for either the claimant or Department of Corrections? Is there anything more Mr. Lee, is there anything more you'd like to tell us?
Yeah, again, when it says that I've been seen several times after the claim, like I said, it should be on file. Like I said, I'll just have to dig through the receipts, but I have it on the sick call receipt that I've been seen about my arm. I've been having issues with this clinic almost the whole time that I've been in prison, and it's almost to like I'm sick of fighting with them because they never know nothing and they never do nothing wrong. And you understand what I'm saying?
Yes, I do. Thank you, Mr. Lee.
Yeah.
Thank you. Appreciate that. If we have no other questions, can we move on to one more claim and then we may stop and take a vote? And this will be claim number 7162, Mr. Zielinski.
This is Unitine Johnson, A3 Cell House, Hutchinson Correctional Facility. I'm away from my desk. If you would leave me a name and number.
Welcome, Senator Straub.
person you have dialed can't take your call.
Why don't we pause just for a second, and we'll go ahead. I will take a motion on the three claims that we just heard, 7141, 7200, and claim number 7160. Do I have a motion on those claims?
Madam Chair, I move denial of claim number 7141.
Do I have a second? Thank you. All those in favor, please say aye.
Aye.
Aye. Any opposed? One opposed. Representative Miller? The motion passed. That claim is denied.
Madam Chairman, I move denial of claim number 7200, Mr. Henry Scott.
Do I have a second? Representative Samsel? All those in favor, please say aye. Any opposed? Okay. Claim denied. Motion passed.
Madam Chairman, on the claim number 7160, in some instances, I might move for dismissal without prejudice under Rule 2, but based upon the complete lack of information or basis for that particular medical claim, I'm going to move denial of claim number 7160.
Do I have a second? Senator Straub, seconds. All those in favor, please say aye.
Aye.
Any opposed? Motion passes. Claim denied. Are we going to go ahead with the next claim, or are we moving on?
Ma'am, we're going to try to contact the next, try again to contact that individual.
7162.
Yes, ma'am, because we think she may have just been away from her desk, so we're going to try that again.
All right. Welcome, Senator Haley.
Ma'am, that point of contact is the same point of contact for the next three claims. So if we
Shall we continue to try? Do you have alternate numbers?
do have some alternate numbers,
Yeah, let's give it a minute so he can get his information loaded. Right on schedule, it's 11:40. Sorry.
Lunchtime. Lunchtime.
Getting all excited, huh?
This is Unit Team Johnson, A3 Cell House, Hutchinson Correctional Facility.
States.
Unit Team Georges.
At the tone, please record.
Hi, this is Counselor R. Brock. If you have any questions, please feel free.
Committee, we are working on trying to get in touch with our next claimants.
This is Unit Team George Whittington, the Hutchinson Correctional Facility. I'm sorry I missed your call.
So, ma'am, we are having some difficulty reaching the point of contact for the next, I believe it's the next 4 claims. So we could move on to the 1115 claim, 7193. Yeah, we did just actually try them, and they're not answering just yet. So I don't know if you'd like to take a 10-minute break, and we'll see if we can continue to try to get either of those folks online.
We'll reconvene at 10:55. We're going to take a 10-minute break. Committee, this is Senator Dietrich again. We're going to start. We have a connection. We are at about 10:55. We have the claim number 7162, Mr. Zelinski, who has indicated he is not going to attend by phone. So we have his claim information in front of us, 7162. So I'll turn over this portion of this claim to the state, to the Department of Corrections, to give their view of this issue. It's a claim for property loss, $165.56.
Thank you. Mr. Zelinski's claim is that he was at work and got moved to Central under investigation and staff packed his property. He alleges that when his property was returned to him, his combination lock, Sangen radio, and Nike shoes were missing. He did file a facility claim. The facility response noted that he had failed to provide any documentation to support his allegations, apart from a May 12th inventory, which did not list the items or include any notation of anything missing. On reviewing the claim, the Secretary's designee noted that inventory forms from May 11th were obtained, and the only items noted as missing were an MP4 player and a fan. Mr. Zelinski had signed this inventory acknowledging receipt of the listed items, including a lock and shoes, and there was no indication that the claimed items were missing. Inmates own property at their own risk, and they're responsible for noting discrepancies on inventory forms. Mr. Zelinski's property was inventoried carefully. Shoes and a lock were included. There's no indication that a radio was present when his property was packed or that staff ever had it in their possession. Mr. Zelinski signed for receipt of the property without noting any of the claimed items as missing. So his alleged losses can't be substantiated, and there's no showing that they were the direct result of staff negligence. So we recommend denial of the claim.
Thank you. Committee, do you have any questions for Attorney Snyder? Very good. We will move on then to claim number 7165. This is Mr. Hill, and I believe he is in the office.
Yes, I've got Mr. Hill here.
Did you put him on?
Here he is.
Hello?
Hello, Mr. Hill. This is Senator Dietrich. I'm chair of the Joint Committee on Special Claims in the Legislature. The committee is hearing the appeal of your claim to the Department of Corrections. It's been previously denied by the department in the amount of $260. You're on speakerphone with the committee, and we have all of your documentation and all of the information for your claim. So I'm going to give you the chance to tell the committee anything else you want us to know about that claim, and when you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. When that's completed, the committee is going to take some time to consider your claim, and then our written decision will be given to you within 21 days following the date of that decision. Does that make sense? Do you understand?
Yes.
Very good. What would you like us to know about your claim?
Yes.
Go ahead and tell us what you want us to know.
Say that again, I didn't hear you.
Mr. Hill, is there anything more you would like us to know about your claim?
Oh, okay. Do you want me to tell you?
Yes.
Okay. Well, I told Mr. Reed, and him and some other officer went into the cell in B1 222, I'm thinking it was, and confiscated my TV. It was a TV. It was slightly new, and I had headphones and a remote and my coax cable, and my headphones had red tape around it from. It was kind of broke. One of the headphones was kind of broke, so I had put red tape around it from when I was working at Electrics. And Reed and some other officer, I don't know who it was, but they got the TV out of there. They told the dude that had it that he had a doctor's appointment, so they could go in there and get it. And they went and got it, and then I haven't seen it since then. And I had talked to another officer and had told him about it, and he went to go search for it, but he went to the wrong cell. I just don't know his name though. But he was the 5-day with Reed at the time, so that's not hard to look up.
Very good. Thank you. Thank you, Mr. Hill. I'm going to hear from the Department of Corrections attorney now at this point in time. Go ahead.
Thank you. Mr. Hill's claim is that an Officer Reed confiscated his television, headphones, and remote from another inmate on August 12th, 2020. He says the officer turned the items over to EAI, the investigations unit, as evidence and charged the other inmate with a disciplinary infraction. According to his claim, he's not received any paperwork about this and his property's not been returned to him. He filed a facility claim citing a date of loss of August 12th, 2020. The facility response noted that the claimed items were not listed on an inventory of Mr. Hill's property on August 8th, 2020. The claim investigator contacted Officer Reed, who stated that he did not confiscate Mr. Hill's property from another inmate, and that if he had done so, he would have completed a shakedown form, and no such shakedown form was located. The claim investigator also contacted the investigations unit, and they advised that they were not holding any property for Mr. Hill. Mr. Hill asserts that the claim investigator should have reviewed the inventory sheet from July 27th, which does include a television. Taking this inventory into account, it appears that a television was in Mr. Hill's possession on July 27th. It was no longer in his possession on August 8th, and there's still nothing to support his assertion that it was later confiscated from another inmate or that staff ever had possession of it. When Mr. Hill's property was inventoried on August 8th, he was not in possession of a television. He alleges that an officer found his television in another inmate's possession on August 12th, but that officer denies the allegation and no evidence was found to substantiate the claim. There's no showing that staff ever had possession of his television or that any alleged loss was the direct result of staff negligence. So we recommend denial of the claim.
Thank you. Committee, do you have any questions? Representative Miller?
Thank you, Madam Chair.
Mr. Hill? We have,
Yes,
we have a question.
man that,
Go ahead, go ahead.
Huh?
Go ahead.
the man that was in 222, he had said that he had got a DR for it. So I don't know about no shakedown sheet, but he said he had got a DR and it had that he had a TV on the DR and stuff.
Okay, thank you. We have a question from a committee member.
Thank you, Madam Chair.
Do I have a question?
Hang on 1 second. 1 second, Mr. Hill.
Okay.
Question for staff. So we do have documentation that there was a TV by this inmate.
In July of 2020, July 27th, but then there was a subsequent inventory
No, I haven't asked a question yet.
Yes, sir.
So there was a TV, and the department's position now is that TV just disappeared?
I don't know about disappeared.
He doesn't have it, right?
It was not in his possession as of August 8th.
And we don't know.
We don't know what happened to it. I don't have any information indicating that we know anything about what happened to it.
Is there a process where they just disappear? If the TV existed, wouldn't it still be in the facility?
Presumably.
But we can't document where it's at.
We have not located it that I'm aware of. I know that, I don't know if it's the same at every facility, but I know that at least some facilities maintain a lost property list or a stolen property list. So when they find something that maybe has the serial number scratched off of it, they confiscate it, and then, you know, they do what they can to identify an owner, but sometimes it works and sometimes it doesn't. I don't know.
Thank you. And Madam Chair, question for the claimant. Sir, why was your TV in somebody else's possession?
Mr. Hill, did you hear the question?
Excuse me? No, I didn't.
Why?
I thought y'all was talking to each other.
Okay, here's the question. Why was your TV in someone else's possession?
Because somebody stole it.
Did you report it stolen when it was stolen?
Mr. Hill, did you report it stolen? Did you report it stolen when it was stolen?
Did I think I did. I'm not for sure. It's been so long.
Thank you.
Thank you. Committee, any other questions? Representative Humphreys.
Thank you, Madam Chair. So just as a matter of process, when.
Yeah, I reported this though. I sure did. Yes,
Thank you. We have another question. Hang on a minute.
My question is for the department.
The staff.
So in this kind of case, I'm sure you have a lot of these things to investigate, but my question is there a process where you might go speak to the other inmate that supposedly had the TV to find out, did he have it? I understand it wasn't in his possession at some point, but what's the procedure to talk to him to find out what happened?
I don't think, and I could be wrong, but not, I don't know, I don't have his claim in front of me. I'm not sure he identified in the claim materials that I have a cell number or an inmate. So I didn't have a
He
DR to
said
look.
a cell number to us a minute, I think.
He did, yes, and I think that's the first I've heard of it. So without any information, I wouldn't have the ability to look up, was there a DR charged? Was a TV found in this inmate's possession? You know, I don't have any history on this inmate because I don't know what inmate's involved. What I have is the facility claim investigation, which says that Officer Reed denies having taken possession of the TV from another inmate. So,
Okay, thank you. Thank you, Madam Chair.
yes, if I had information like that, we would certainly look into those things.
Thank you very much. Any other questions? Thank you, Mr. Hill. We're now going to move on to another claim, claim number 7181, and it's, the claimant is Mr. Garcia. Is Mr. Garcia present?
Hello,
Yes, we're looking for Mr. Garcia.
this is, okay, let me have the officer, take Mr. Hill back to his cell and get Mr. Garcia for you, because they're in, restrictive housing, so it'll be just a couple of minutes. I'm sorry about that.
Thank you. That's
All right.
Would you like
Can you
to
get Mr. Garcia for
vote
me?
on the claims
All right,
we've
thank you,
heard?
sir.
Since we have a couple minutes? What happened to Mr. Sims? I'll take a motion on claim number 7162.
Madam Chair, I move to deny claim number 7162 for the claimant's refusal to appear or cooperate in the process.
Thank you. Do I have a second?
That was quick, Mr.
Second
Hill.
on 7162, motion to deny. Representative Samsel, all those in favor signify by saying aye.
Aye.
Any opposed? Motion passes. Claim number 7165. Do I have a motion?
Madam Chair, I move to deny claim number 7165.
Do I have a second? Representative Samsel? All those in favor, please signify by, I'm sorry. Oh, discussion. Yes, thank you. Yes, Senator Haley.
You know, again, I just, for those who are new to the committee, I continue to have some serious concerns about procedurally the ownership. For those who've been here for a while, you know, that I have to suggest that where these instances come up, and they come up quite a bit, the possession of someone's property, especially something bulky like a television, it concerns me that through no fault of the claimants, but the departments more than anything else, that they're losing something of such value. So, you know, I just don't think this exists in a vacuum, and I always make, for whatever it's worth, the substitute motion that we approve half of the claim, because again, I've always said now publicly that the department is certainly, corrections is as much at fault, despite the KAR, whatever it is, 105, that Snyder tells us about, that if you're incarcerated, you have no right to own anything, which is basically a statute that needs to be reviewed, or regulation as far as I'm concerned. But I do make the substitute motion that we approve half of it. This man lost his television through no fault of his own. It's difficult to replace it, and sorry for the ongoing dialogue, monologue, but I would make the substitute motion that we approve for $130.
So we have a substitute motion on the table, but we haven't voted on our first motion. So procedurally.
A substitute would proceed,
Okay, so do I have a second on the substitute motion to approve half the claim? Hearing no second, that substitute motion then fails. Thank you, dies. So the motion on the table is to deny the claim number 7165. We have a motion and a second. We've had discussion. All those in favor signify by saying aye. Aye. Any opposed? One opposed. The claim is denied. Motion approved. Thank you all. Are we ready for Mr. Garcia now? That's quite all right. We have two claims for Mr. Garcia, 7181 and 7182, as soon as he arrives.
Yes. They're on their way with him now. He is in a wheelchair, so he'll be coming in here just shortly.
Mr. Garcia?
Yes, ma'am.
You got Joint Claims Committee on the phone, sir. Here's Mr. Garcia.
Hello, Mr. Garcia. Can you hear me?
Hello?
Hello, Mr. Garcia. This is Hi, this is Senator Dietrich. I'm chair of the Committee on Special Claims in the state legislature. We're hearing the appeal of the first claim. You've got two claims here. So the first one we're going to hear is claim number 7181, and it's for property damage in the amount of $109. So you're on speakerphone with the committee. The committee's got all of the documentation for your claim. When I'm done, I'm going to ask you to tell us anything you'd like us to know about that. And I'm also going to ask the attorney for the Department of Corrections to give the department's view of the issue. And when that's completed, the committee's going to take some time to consider your claim. Then we're going to give you our written decision within 21 days of making our decision. Do you understand?
Okay.
Very good.
ma'am.
So the first claim, 7181, $109. Is there something more you'd like us to know?
Yes, I see that they gave you a receipt on, let me see, the checklist, an electronic checklist on the back of my, let me see, on the back of the paper they sent me, I have a paper here from Mrs. Libby Snyder.
Yes.
Okay, and on there she writes that that I got my MP flare on April 21st, 2020. Okay.
Yes.
And on the back it says that I signed for it for 21/2020. Here in SEG, you cannot have the Edge mini player, so they never gave me that. There should be another pink paper that says SEG non-allowable, and that would have shown that my MP was still kept in property. It was in a box with my prosthetic and other heavy stuff, and I think that's what damaged it. I mean, yeah, you can see right there on the electronic checklist that they're supposed to fill out where it says it did work before when they had it. The volume works, the switch works, and all that stuff. And then, like I said, when I got out of the hole, that's when I put the property claim. I talked to the unit team the first day I got out, and I told her that it wasn't working. And we waited until we tried to see if it was going to work or not, and then it didn't work. So that's when we were finally able to fill out that property claim.
Thank you. Thank you for your explanation. Attorney Libby Snyder next is here to present on behalf of the Department of Corrections. Go ahead.
Thank you. Mr. Garcia did file a facility claim regarding the alleged loss of his MP3 player, or the damage to it. He cited a date of loss of December 15th, 2020. He said that his property was taken to Central on April 18th of 2020, and his MP4 player was working before it was inventoried. He said it was returned to him in a box with non-electronic items, and if he'd been allowed to pack his property, he would have packed the player separately from other items. The claim response noted that Mr. Garcia had signed an electronics inventory on April 21st, 2020, indicating that the MP4 player was returned to him and no damage was noted. Inmates own property at their own risk. They're responsible for noting discrepancies when signing inventories. Mr. Garcia signed for receipt of the MP4 player on April 21st, 2020, without noting any discrepancies. So his alleged losses cannot be substantiated, and there's no showing that it was the direct result of staff negligence. Any allegation that that would not have been allowed, or that the facility claim response was in error about his having signed for the player on April 21st was not made in his present claim until today.
Mr. Garcia, do you have any further response?
Okay. I have a unit team here. Can you tell them that we can't have our MP3s in the hole, so I couldn't have received it on that day?
Thank you.
Can she testify or whatever? I have a unit team member here. She's the one. She'll be able to let y'all know that we cannot have the MP3s in the hole, and they couldn't have given it to me. I didn't take it that day. What I did accept was my fan and my TV, but the player we could not have it. We can't have it in the hole. They won't allow it.
Thank you. I'm not sure that we need the witness, but committee, do you have any questions of either the attorney or the claimant? Yes, Representative Humphreys?
Thank you, Madam Chair. Sorry, just procedural question again. So when someone receives their property back in a box, is it just, okay, here it is, sign, you got it?
No, they're supposed to be given an opportunity to inspect the property, note anything that's missing right there with the officer, the property officer.
Given time
Yes.
to do that? Because also notice on his claim that he said that it seemed fine, and then when he played it, it wouldn't stay on. And so it might have looked fine. That was what my question was.
And that is a possibility. But again, it could be that it wasn't working when we took possession of, I mean, it's equally likely that it was already not working, but it looked fine. We packed it, whatever. I mean, it's a possibility. It's something I can't prove or disprove, but once he's taken possession of it, we can't prove that any damage didn't occur after he took possession of it. He signed the inventory saying it works. Often staff will try to work with an inmate and do what they can on something like that, but it could cut either way on those.
Thank you. Thank you, Madam Chair.
Thank you. Any other questions? Any members? Representative Miller?
Thank you, Madam Chair. Pardon me for being thick, but this particular item was okay to have in certain places in the facility, but not others. That's why it was seized.
No, I think what I understand the claim to be that he was moved to SEG, and that's why all of his property was packed. And then on April 21st, I have an indication that he signed for receipt of his electronics. He is saying, I couldn't have signed for receipt of that item because it wouldn't have been allowed to me on that date in segregation.
And is that true, or do you know?
I don't know, it may be, and he's asking the unit team to
Can't we
attest to
ask
that.
if the person's there, if they can verify that that's policy? Well, I'd just like to know what he's saying.
Certainly not something that he made, it's certainly not something that he alleged in his present claim, even though the answer to the facility claim was, you signed for it on April 21st. He did not appeal to this committee saying, I couldn't have because it was SEG. What he said was,
I understand. But
Yeah,
what
so-
he's saying now is that
yes,
he's not allowed to have it in.
So he couldn't have signed for it. Is the unit team leader there?
Yes, ma'am.
Is your unit team leader there?
Yes, ma'am, she is.
Who is it?
Here you go.
Hello. This is
Hello,
Unit
could you
Team
identify
Johnson.
yourself for the committee, please?
Unit Team Johnson, Hutchinson Correctional Facility, Unit Team Supervisor, A3 Cell House.
And do you understand the question that the claimant has asked us to investigate?
Yes, he's saying that in restrictive houses segregation that they are not allowed to have their MP3 or 4 players, which is true. They are not allowed to have those while they are in segregation any longer. They used to, but that has stopped.
Follow up, what happens to the property while they're in segregation?
Well, they're in segregation. The property is stored in our property storage in admission and discharge.
Okay, thank you.
All right, I'll put Mr. Garcia back on the phone.
Any other questions, committee?
Okay, I'm back on.
All right, Mr. Garcia, we've got another claim from you. We're going to move on to claim number 7182. It was property loss, $90.58. Again, we have all the information in front of
Yes,
us.
ma'am.
Would you like to explain what happened?
Yes, ma'am. The officer that does the hearings, the one who does the disciplinary hearings, he came by and he asked me about my a dealing and trading that I had got written up for, and I said, he said, how do you plead? I said, not guilty, and he asked me why, and I said, well, I made cards over there at the East Unit. At the East Unit, the officers in charge will allow you to pass 4 sealed items for handicrafts, stuff like that. I'm an amputee, so I can't get a job really. So I'm indigent, and that's how I made my living, my money. I'd make birthday cards, Christmas cards, et cetera, you know. And I even put in a witness slip for an OIC for the officer in charge Forehand and an officer in charge Nunez. But that day when when Officer Brown came by and did my hearing, he didn't call them. So, but I did put that thing in, and he asked if they were sealed and all that. I said yes, they were. He said, I said, well, when they packed my stuff out, they grabbed it from my box. I was in a single man cubicle, so anything they take from that from the locker belongs to me. So they couldn't have said it belonged to anybody else. It's mine. And I told him that, and he said, okay. I told him that the officers allowed us to get the 4 items. He said, okay. And he said, all right, I'm going to find you not guilty. And then I said, okay, can I get my stuff back? He said, yeah, you should be able to get it back. Then I wrote to unit, let me see, that was on my hearing was on the 24th. On the 24th, and I wrote the EAI where they had my evidence, where they withheld my stuff, my food, and my soap and stuff like that. I wrote them on the 30th, asking for my stuff back, and they told me to write to the unit team that I should be able to get my stuff back, and they never gave it back. And then my unit team, I wrote her also, and she wrote me back on 5/1, and she said she checked with ENI, and they did not have any of your property. The canteen items they had were destroyed per disciplinary, but I was found not guilty, so they shouldn't have destroyed it or gotten rid of it. That's all.
Thank you. Thank you. We'll now hear from the Department of Corrections Attorney Libby Snyder.
Thank you. Mr. Garcia's claim was that he was found not guilty of a disciplinary charge for dealing and trading, but his property wasn't returned to him. And he states that 4412-205 permits the warden or staff to authorize dealing and trading, and he had authorization from staff. He says his due process rights were violated because they stole his money after he was found not guilty. He filed a facility claim regarding this. There he stated that he had been found not guilty, and he had earned the items by creating greeting cards for other inmates in exchange for canteen products. He asserted that he had staff permission to do so, and he requested that the items be returned to him. The facility claim response stated that such exchanges would not be permitted by KDOC policy, and his canteen purchase records showed that all that he had purchased of the claimed items was 3 root beers, and that was in December of 2019. KAR 4412-205 prohibits the trading of goods or services between or among inmates without written permission of the warden or designee. Mr. Garcia has never offered any evidence or allegation of having received written permission from anyone. On April 19th of 2020, Mr. Garcia was charged with unauthorized dealing and trading. He did not request any witnesses, and today he says he did, but if you look at the attachment A to our recommendation, that is the testimony from the disciplinary hearing. Second line down, inmate Garcia was sworn in, the DR was read into the record, there wasn't a witness slip submitted. And then the inmate entered his plea. Mr. Garcia did not request witnesses, and he did not argue that anyone had given him permission to exchange cards for canteen items. Instead, he testified that wasn't my stuff. Based on this, he was found not guilty, and the hearing officer ordered that the evidence be destroyed. Inmates own property at their own risk. His claim is for canteen items that he did not purchase. He offers no documentation to show that he received permission to obtain the items through dealing and trading. And at his disciplinary hearing, he denied that the items were his. He's not entitled to compensation for items that were obtained in violation of prison regulations, nor is he entitled to compensation for items that were not his. We recommend denial of the claim.
Thank you. Committee, do you have any questions for the attorney? Yes, Representative Humphreys.
Thank you, Madam Chair. I'm a little bit confused on, it seems like he was found not guilty. So he's not guilty, but what I hear you saying is that he did something that was against the regulations, right. Not understanding.
He was found in possession of items that he hadn't purchased. That's why he was charged with dealing and trading. He must have obtained these items through some other means. At the disciplinary hearing, what he said was, those weren't mine. And that's why he was found not guilty, because they couldn't establish a chain. It does say in the disciplinary hearing, they couldn't establish a chain of evidence. So the discipline was dismissed. But because he had said those weren't his items, there was no reason to return those items to him.
Okay, so then it seems like it's a new case that you're accusing him of, and that's why he can't get the, I mean, he was found not guilty of that.
Right.
And so now, okay, second question. I've heard money, I've heard canteen items. What is the $90? And maybe that's a question for him, because I don't understand what the $90 is.
I think it's the value of the canteen items that he claims he purchased.
Mr. Garcia?
Purchased through greeting card.
Yes, ma'am.
What exactly is?
Yes, ma'am.
What exactly is the $90.58? Is it cash money, or is it the value of the canteen items you purchased?
No, that's what all my stuff added up to, with my soaps and my, the hygiene and my chips and, cheese and stuff like that. Canteen items. And, that's silly for them to say that it wasn't my stuff. It was in my locker. There's nobody else it could have belonged to. Obviously it's mine. I told him it was mine.
Thank you, Mr. Garcia.
That's what the write-up is unauthorized dealing and trading it, not guilty. And it was authorized because the COs give it to us. I mean, I don't know if it's an unwritten rule or how they do it, but when an officer in charge lets you do something, then I mean he's speaking for the warden or he's speaking for the facility. I'm sorry, I'm rambling. Okay.
That's all right. Thank you. Any other questions? Representative Ralph.
Yeah, for the state. So where in the materials, is there a place in the materials where we find the basis for the not guilty finding?
Yes, the disciplinary hearing record is attached to my recommendation. And then at page 4 of 7 of that attachment, that's basically what would be a transcript in a real trial. This is the summary of the testimony given at the hearing. And the hearing officer states that the inmate entered a plea of not guilty. Garcia stated that wasn't my stuff. So then the hearing officer attempted to connect the stuff to him and went and found that the chain of custody was broken. And so there, on that basis, that it had to accept that it was not his stuff and found him not guilty of dealing and trading. He did not argue at that hearing anything about greeting cards.
Yes, Representative Ralph.
So, Mr. Garcia, did you tell the hearing officer?
Yes, sir.
Did you tell the hearing officer that wasn't my stuff?
No. I mean, even when on the write-up it says they took it out of my locker, it's my stuff. I told him it was my stuff. I told him exactly that I drew the cards. I do them Christmas cards and birthday cards and stuff, and that's how I get paid because I'm indigent and I can't afford a job.
Stop for a second.
Yes, sir.
I'm not talking about when they took your stuff. I'm talking about at the hearing, when they found you not guilty. At that hearing, did you tell the hearing officer that wasn't my stuff?
No, I did not.
So you're saying that
I told him it was my stuff.
Okay, thank you.
So there's a conflict with the testimony. Yes. Representative Miller.
If I could follow up on both the representatives' questions. We have an attachment from the department, and it's labeled, one of the pages is labeled testimony. Who prepared that summary?
That would be the hearing officer, disciplinary hearing officer.
Well, with all due respect, that summary makes no sense. It says the last sentence says, based upon the preponderance of the evidence in which the facts don't support the charge, it is more likely than not, in the hearing officer's opinion, true, the incident did happen and the following sanctions were imposed. And then it says, not guilty. So, and it doesn't list any sanctions. It doesn't say anything there about destroying the property. It doesn't say,
That's on a separate form,
all right,
on page
Go-
3 of 7, just before, the page just before that,
before that,
about a third of the way down, almost half, disposition of evidence, canteen items to be destroyed.
I saw that, but I don't understand why it's not part of this summary of the testimony. The finding that we're looking at as part of the summary is in direct contradiction to destroying stuff. So I don't know if he or she was confused and checked the wrong box, but
My reading was that it was.
his findings if the inmate indicated it wasn't, quote, his stuff, the finding seems inconsistent with that testimony.
I would say that that paragraph, which sort of does seem to indicate that there was going to be a finding of guilt, conflicts. I don't think that the actual finding is inconsistent, though, with the testimony. I think he was found not guilty, which is consistent with accepting that that property wasn't his. And he's not appealing the DR here. He's not appealing the disciplinary charge. And I don't know if he did.
Well, he wouldn't be appealing the disciplinary charge because he won.
Right.
Why would he appeal that?
But at no point in his claim does he say, that's not what I said in the hearing. I mean.
Well, it's what he just said.
Yes.
And there's no recording. Who are these hearing officers? How are they selected and who do they work for? Are they independent, or can you just help us out a little bit?
Corrections officers trained for the position.
Department employees?
Yes.
Thank you.
Committee, any other questions of either staff or the claimant? Mr. Garcia, thank you for your presence today. We will consider your claim and get back to you within 21 days.
Okay, I was going to ask y'all, instead of getting money, can we just can they settle and give me canteen items here at the facility? I mean, it'd be a lot faster for everybody, I think, if I win.
Thank you for your suggestion, but that's nothing that we have the authority to do. Thank you, though. Our next claim is claim number 7193. Mr. Everson, we have two claims for Mr. Everson. Same facility? Different unit.
Hello?
Is this Mrs. Brock?
Yes, this is Counselor Brock.
Hi, this is Meredith with the Joint Committee on Claims Against the State. We were trying to reach Mr. Everson.
He's sitting right here.
Okay, thank you.
Yep.
Mr. Everson?
Yes.
Hello, this is Senator Dietrich. I'm Chair of the Committee on Special Claims in the State Legislature. The committee is hearing the appeal of your claim. You have two claims here. The first one we're going to deal with is claim 7193 for $124.45. You're on speakerphone with the committee, and we have all of your documentation for your claim to be able to review. And I'm going to give you a chance to tell the committee anything more you want us to know about that claim. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. When that's completed, the committee's going to take time to consider your claim, and then our written decision will be given to you within 21 days following the date of that decision. Do you understand?
Yes.
Very good. Mr. Everson, do you want to talk to us about claim number 7193?
Okay, that's the 124.25.
Yes.
Okay, this happened on 12/18. They took me to the clinic and put me on crisis level. When they took me to the clinic and put me on crisis level, the clothes I had on, as listed on here, was my Red Wing work boots. I had a white T-shirt, a do-rag, some jersey shorts. I had a level 10 lip balm. I believe that's all I had. But when they take you to the clinic and put you on crisis level, they don't pack your property out per se, but they take all your clothes off of you and they put them in a plastic bag, and it's left wherever they leave it in the clinic over there. About 1 o'clock in the morning, 2 o'clock, somewhere in that area, they removed me from the clinic from crisis and put me in A1 cell house, I believe 106. And at that time, from leaving the clinic, I still was not given any of my clothes, any of my property. It was in a bag, a plastic bag, and when I went over, they took me over to A1. It was in turn set up on the table, and he told the officer that was working there, and I forget the name, that was my property. In A1 cell house, you can't have none of the stuff that I wore, because they give you your own boxers, T-shirts, socks, pants, and shirt for that particular unit. What happened to my work boots and all that, I have no idea, because they never gave me the shakedown report or property report, stating that they received it, where it was placed. When I got ready to get out of SEG, I think maybe a week or two later, whatever it was, I was trying to obtain my property back. But at that time, nobody knew where it was at because I didn't have a property sheet. They didn't do a property receipt on it. And all I could do was tell them it was brought with me by the officer when they brought me over to SEG early that morning.
Thank you. Thank you, Mr. Everson. We're now, committee, I think we'll hear from the staff attorney, and if we have any questions, we'll do so after we hear the department's position.
Thank you. Reviewing the facility claim on this one, the facility claim investigator reviewed electronic logbooks and determined that Mr. Everson had been placed in restrictive housing unit on December 18th at approximately 2:24 a.m. Shift briefings indicated that his eyeglasses had been returned to him the following shift. The investigator interviewed staff who were working all shifts on December 18th and 19th. One staff member recalled Mr. Everson's arriving in boxers, a t-shirt, and Crocs. It was noted that it was unlikely that he would have been wearing his boots at 2:42 a.m., and there was no video available to be reviewed. However, the inventory of his property on December 19th was reviewed, and it included a pair of black boots, a do-rag, 2 white t-shirts. Mr. Everson signed for receipt of his property, and a note on the inventory indicates that he was missing, quote, all personal effects taken from him when he went to SEG, including but not limited to a pair of Red Wings, which would be boots, shoelaces, several canteen items, 1 white t-shirt, and 1 mirror. The claim investigator reviewed his canteen history and accounting history for the previous 7 years and found no record of purchase for any of the claimed items, nor had Mr. Everson provided any receipts or proof of purchase for the items. Inmates own property at their own risk. They're responsible for noting discrepancies when signing inventory forms. His property was inventoried, and except for the shorts, the claimed items were listed on the inventory. It was noted on the inventory that Mr. Everson claimed some items were missing, but there was no record of his ever having purchased those items. Though this was cited as the basis for the denial of his facility property claim, Mr. Everson still has not provided any proof of purchase with his present claim. The claimed values cannot be substantiated, and he's not entitled to compensation for items that he did not purchase. We're recommending denial of the claim.
Thank you. Committee, do you have any questions of either the claimant or staff? Yes, I'm sorry.
Yeah, for Libby. Okay, I'm hanging up on the boots here in some fashion, so I'll focus on them because they just kind of stand out in the middle of this. So, and I saw in there that they went back and tried to review video, but we didn't have video that far back to know. So one way or another, that just seems like an odd thing to have there. But if he had a receipt for the Red Wing boots so that a value could be established, would that affect your position here?
I think it would. I think that the position here is that of all the things that he claimed, he had no purchase history for any of them, according to the facility claim response.
Okay, but does the purchase history affect whether there's a value that we could allow him, or does it go to the core of the claim of whether he can be reimbursed at all?
I think think the latter. The problem with this one is that where he notes discrepancies, it's vague. It doesn't say, I am missing my boots, my t-shirt, you know. It says I'm missing everything, including these 2 items and maybe more. I don't have any way to investigate most of that. So maybe he had boots, maybe he didn't. Maybe he had purchased them, maybe he hadn't. Maybe we could find a value, maybe we couldn't. But there's no purchase history for any of the claimed items, whatever those are. I mean, we know what he's claiming, but I can't establish ownership, I can't establish presence, I can't establish value, you know.
One more question, if I could, Madam Chair. The notation on there at the bottom, is that his notation or is that a CSI's notation?
I'm not sure. I think it is probably staff, and I think it says, inmate says, or inmate claims. Attached to the next claim.
Inmate is missing
I didn't put
all
a copy
personal
because it's
effects,
attached to his
so-
claim. The copies of the inventory are attached to his claims.
So it's probably a note from the staff person there with their little signature at the bottom and a date.
They don't always sign them. I sometimes look at these inventories and I have no idea whether the inmate wrote it, whether it was written at the time or after. You know, I have to go back and get original copies to be sure. And then sometimes we have to interview the staff and say, do you remember this? Did you write this?
Well, I'm just, in looking at the note, there appears to be an obvious signature at the bottom of it with a date of 1/22/21, so.
Is that the one with the signature at top, or with the notation at the top? Okay, okay.
Madam Chair, if I may just note that I see the signature, and that the signature does match the offender's signature, which is, or it's very similar, right above it.
Thank
The
you.
officer's signature or the offender's?
It's signature of the offender.
It looks like it, to me, that it matches the officer.
That is correct. I was in error. It matches the signature of the officer.
Thank you.
Thank you, Madam Chair.
Representative Sampson.
Thank you, Madam Chair. A similar question. In order to own or possess the property in there, are they required to have the receipt throughout? Or is that if it just comes up missing later?
I don't think they're required to keep their receipts. We have a certain record, we have a record of what's purchased in our canteen, we have certain records that we keep. Fundraiser records, depends on the fundraiser, what and whether we can get receipts to prove those things. Inmates own property at their own risk, so it is in their best interest to maintain those receipts. So that if we can't locate it, or for whatever reason, they have their receipts.
Thank you. Thank you, Madam Chair.
Any other questions? Representative Miller, then Representative Humphreys. Representative Miller?
For the claimant, Mr. Everson, how long did you own these boots?
About a year and a half. Something that was said as far as my boots, the t-shirts, the do-rag.
No, sir, I just want to talk about the boots. And you said you owned them for about a year and a half, correct?
I have a receipt in my property. I have that receipt.
And have you been asked to produce that receipt?
Yeah, I do have a receipt.
I
believe I got this. My boots came from a property claim that was paid off by Unity Pettyjohn.
Have you been asked to produce that receipt as proof?
I have not. No one has asked me.
And you do still have it?
Yeah, I have receipts for all this stuff. Yeah.
Well, particularly for the boots, can you produce that receipt for the committee?
Yeah, I have to get it out of my file in my cell. I don't have it in here with the Unity, but I can get it from my other paperwork.
All right, thank you.
Representative Humphreys?
I'm fine, thank you.
Okay, very good. Mr. Everson, we're going to move on to your second claim, 7195. That's for the amount of $1,354.63.
Gotcha. You want me to start or?
Mr. Everson?
Yes.
You can go ahead and tell us anything you'd like to know about that claim. We have all the documentation in front of us.
Okay. This was on the same night I have been released from what they call crisis level, and I've been sent back to my cell. And then we ended up getting all packed out and moved out again that night or that next morning on the 19th. And the problem is, all our property was mixed up together. I think I included one of the shakedown sheets that had my hot pot and some other stuff listed on it with this. And it was supposed to went to the unit team, and I have a unit team response from the one it was supposed to went to, who said even though it was on the shakedown sheet and was supposed to went to the unit team's office, it was never placed in his office. And he told me on this Form 9, which the unit team is in here with me right now, can look at, the next thing I can only do would be to file the property claim because they didn't have none of the property that was supposed to be listed. But again, I said the major mix-up with this, the whole property is when they packed us out, they packed, I think, like 4 of us out of the same cell, and all our property was mixed in together. I don't know what all mine they got that I didn't get back and vice versa. But that's why I lost a lot of stuff. And I think on there I had listed my watch and some other stuff that Unity Hayes found that wasn't even with my property. Somehow it ended up in the drawer in the clinic. So my property was just everywhere, and I still haven't recovered it all.
Thank you. Ms. Snyder, could we hear from the department, and then we'll open for questions?
Thank you. Mr. Everson's claim is that his cell was searched on December 18th and 19th, and officers left his locker unlocked after completing the search. He then alleges that in a second search, his property was mixed with that of other inmates. He says a hot pot and other items were listed on a shakedown report as having been turned over to the unit team, but the items were not located in the unit team office. He seeks compensation for a hot pot, religious necklace, MP3 player, a thermal top, t-shirt, radio, pads of cardstock, shoelaces, shower shoes, mirror, lock, assorted food and hygiene items. He did file a facility claim. There he stated that his cell was searched while he was at the clinic, and his locker was locked before he went to work in the kitchen, but it was unlocked when he returned to the cell. He stated that officers packed his property on December 19th, and all other property came up missing. None of the missing property was in storage when he was released from segregation, which was noted on the inventory sheet. He also asserted that some of the property was to be held in unit team in D1, but they stated that it had been sent to A and D for storage, where it was not located. He argued that officers had opened his lock, thrown things away, and either packed his property with other inmates' belongings or intentionally left or gave away his property. The facility claim response noted that Mr. Everson had been sent to the restrictive housing unit on December 18th for pre-hearing detention and returned on January 22. The property that was packed out was all that was available at the time. The claim investigator noted that there were discrepancies between what he had claimed was missing at the time and what he had listed in his property claim, and that his assertion about the locker being left unlocked was pure conjecture. Attached to his present claim is a shakedown report that lists some of the claimed items. There is a religious necklace described as altered, pads of cardstock listed as destroyed, a hot pot listed as having been turned over to unit team, and a bottle of aloe vera lotion was destroyed as not an original container. Altered property is contraband by regulation, and the regulation provides that it shall be confiscated and the inmate forfeits rights to it. One of the claimed items in his present claim is a white t-shirt. He also included white t-shirt in the previous claim, 7193. And as noted in the department's response to that, the facility claim investigator found no record of purchase for the claimed items in the preceding 7 years. Mr. Everson is not entitled to compensation for items he did not purchase. Many of the remaining claimed items are listed on property inventories attached to his claim. He signed for return of some of the property on December 19th and the rest on January 22nd. On December 19th, it was noted on one page of the inventory, some property is missing, some food, a shirt, MP4, and some other items. On January 22, there's a notation on one page of the inventory that inmate is missing all personal effects taken from him when he went to SEG, including but not limited to 1 pair of Red Wings shoelaces, several canteen items, 1 white t-shirt, 1 mirror. It is impossible to determine from such a nonspecific notation what items were reported as missing at the time and which items he was acknowledging receipt of. Also attached to his present claim are documents indicating that he was given a thermal top on December of 2020 and that he received an MP3 player on August 27th of 2020. Again, he's provided no receipts or proof of purchase for the items and nothing to establish their value. We do note, however, $994 worth of his claim is for songs. But even if it were established that his MP3 player was missing, he would still have access to purchased music, which could be downloaded on another player. Excuse me. Inmates own property at their own risk. They're responsible for noting discrepancies when signing inventories. Mr. Everson's property was inventoried. Most of the claimed items were listed on the inventory. Notations on the inventory indicate that he did claim some items were missing, but far fewer items were specified than are now claimed. Excuse me, so close to the end. For some of the items claimed, no purchase history has been identified. Some of the items claimed were specifically identified as altered. With no receipts or record of purchase, the claimed values cannot be substantiated, nor can ownership, and Mr. Everson is not entitled to compensation for contraband or items he did not purchase.
Thank you. Committee, do we have any questions of either the claimant or staff? Representative Miller?
For the claimant, Mr. Everson, can you produce receipts for any of these items you claim are missing?
Yeah, the facility keeps a list of everything I purchase at the store every week.
No, sir.
Go
It's
every
not,
week.
no, sir. No, sir, that's not my question. Listen to my question. Can you produce receipts for any of these items that you claim are missing?
Yeah.
Okay, would you do that, please?
Yes.
Thank you.
Thank you. Committee, any other questions? Thank you. So we have, we're running about 30 minutes behind. We've got two claims, 7194 and 7196, that we need to hear. And then 7199, I believe the Department of Corrections is going to indicate you want that to be carried over.
Yeah, that was one that we didn't receive until early September. We just didn't have time to get it investigated.
So I'm thinking, before we break for lunch, we should hear these two claims because those inmates may be waiting for us. Would that be all right? You do? Okay. Do you want us to wait on our votes? Okay. Are you like leaving for the? Gotta go. Okay, thank you very much. Okay. We need to hear claim number 7194, which is Stephen Hayward.
Hutchinson Correctional Facility, this is Unit Team Bentley.
Hello, my name is Meredith with the Joint Committee on Claims Against the State. We were trying to reach Mr. Hayward. Is he available?
Yes, he is.
Hello.
Mr. Hayward? Mr. Hayward, can you hear me?
Yes, I can.
Very good. This is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the Legislature. The committee is hearing your appeal claim to the Department of Corrections. It's been previously denied by the department. It's in the amount of $585.93. You are on speakerphone with the committee. We've been given all of the documentation for your claim for our review, including your description of the loss. But in a minute, I'm going to give you the opportunity to tell us anything more you would like us to know about your claim. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department's side of the issue. And then when that's completed, the committee's going to take some time to consider your claim, and our written decision will be given to you within 21 days following the date of that decision. Does that make sense to you?
Yep, sounds good.
Very good. Would you like to tell us anything more about your claim 7194?
Yes, can I just give you a real quick rundown, like just take a couple minutes? First of all, I've been in prison 25 years. I've never filed claims when I lose stuff. I usually am just lazy about it. I don't care. But this time they literally lost all, I got the coronavirus, went to Lansing, came back. And the reason that this states that, about inventories and the initials weren't on the original, because the policy here where I was at in A2 and A3 and segregation here, they make you sign and Wilson will surely tell you this if you guys get a hold of him. He was the sergeant. They make you sign your sheet before you even open your boxes because they cuff you up and they throw your boxes in your seg cell. So and I literally said, hold up, before you go running off, let me check my boxes and make sure everything's here. And that's exactly how that came to be. And so what happened was there was two separate pile of copies, I guess, and I didn't realize when I made my initial claim that his name and date and all that wasn't on the top, because that was the part that I signed before he even threw the boxes in my room. And when I realized that the signature wasn't on there, I looked at my paperwork and realized that I had the copies that he signed. And everybody there was aware of it. That all the sergeants on all three shifts were trying to find it for me. And I mean, I don't care what you guys call everything. I don't care if you give me the pennies for this stuff. It's just I really did come back to everything being gone and all my property. I really just wanted it back. I'm not trying to get over. I mean, I did everything I was supposed to do correctly, I believe, from the time that they handed me back my property with the. I could tell there was boxes missing, a box and a half at least, and that's why I stopped him. He never left my side, and never left my side. He gave me the boxes, cut me up, and watched me in my room, and then signed off on everything I had, everything I did, and signed and dated it. And let the next shift know, Sergeant Miss Smith. And I had believed I did everything right. Now, I didn't put the right paperwork in the initial claim because I didn't realize that his signature wasn't on. I had made that mistake, but they will, I'm sure they'll vouch for the fact that is how they do that in the seg here. You can't go through your property until it's in your room, and you have to sign before you even look in the boxes, which I thought was, and that's pretty much it.
Thank you, Mr. Hayward. Appreciate that. We'll now hear from the Department of Corrections Attorney, Libby Snyder.
Thank you. Mr. Hayward states that he was given what appeared to be his property, but upon further examination, he determined that the majority of his property was missing. He says this was marked by staff on the return property form. He requests compensation for batteries, charger, craft items, legal folders, headphones, earbuds, etc. On February 12th, he filed a facility claim. There, he stated that he had been transferred to Lansing Correctional Facility for quarantine and then returned to Hutchinson Correctional Facility, and where most of his property was missing. He alleged that this was reported to cell house staff, who were told that there was no additional property in storage for him. The facility claim investigator noted that Mr. Hayward had signed all property inventories upon his return, and there were no notations of anything missing. With his present claim, Mr. Hayward includes copies of the inventories that do have a notation at the top of the page, stating that only the check-marked items were received and the rest was missing. The notation appears to be signed by CS1 Wilson. Facility staff advises that the notation is not in Mr. Hayward's property file. And CS1 Wilson works in a different unit, so it's not clear whether or how he would have been involved in the matter. An attempt was made to contact CS1 Wilson, but he is on vacation. Additionally, it is noted that he has requested $150 for 4 photo albums, but the inventory lists only photos, and by policy, he's only permitted to possess 2 photo albums with a total value of $20. He also requests $180 for 4 folders of legal work, but there is no legal work listed on the inventory. There is a listing for 4 miscellaneous paper folders, but this line appears to be checkmarked on his copy of the annotated inventory, indicating that he did receive those. Inmates own property at their own risk, and they're responsible for noting discrepancies on inventories. Based on the documentation in his official property file, Mr. Hayward signed for receipt of his property without noting any discrepancies. He has now presented additional documentation to assert the discrepancies were reported to staff, But these documents do not appear in his official property file and cannot be investigated until the staff person returns to work. Based on this, we recommend that the claim be carried over to a later hearing to permit us to further investigate regarding the documents that he has presented.
Thank you for that. Committee, do you have any questions? Very good, thank you. I think I'm in agreement with the carryover, and we'll probably make a motion for that at the appropriate time. Thank you. The next claim that we'll hear is claim 7196. That is Charles Denmark Wagner, property loss of $8.
Hutchinson Correctional Facility, Unit Team rolling.
Hello, my name is Meredith with the Joint Committee on Claims Against the State. We are trying to reach Mr. Denmark Wagner. Is he available?
Yes, hold on, please. Hello?
Mr. Denmark Wagner?
Yes.
Hi, this is Senator Dietrich. I'm chair of the Joint Committee on Special Claims in the state legislature. We're hearing your claim it's claim number 7196 for $8 for property loss. You are on speakerphone with the committee. We've been provided all the documentation for your claim, including a description of the loss. I'm going to give you a chance to tell the committee any additional information you would like to in just a minute. When you're done, I'm going to ask the attorney for the Department of Corrections to give the department side of the issue. When that's completed, the committee is going to take time to consider your claim, and then our written decision will be provided to you within 21 days of the date of that decision. Do you understand?
Yes.
Very good. Go ahead and tell us about your claim.
Okay, so, excuse me. In here, if you receive anything in the mail, whether it's pictures, letters, magazines, or on the JPay, which is our like online mail system that they have for us, it is censored before it ever gets to you. Now, if it's censored, you will never see it. You can appeal the form, but you can never see what it is. You have to appeal it blindly. But if it's not censored, it'll come through for you. Well, I received these pictures, and they came through on the JPay, so that means they already passed the censorship. So when I tried to print them off, another person chose to censor them, and they still took my money for me being able to print them. Now, if it was already approved by the censorship and somebody else chose to censor them later, that's not my fault that they have two different opinions on what is allowed and what's not. That's why I said that it's not my fault that they weren't printed out and given to me, and they still took my money for printing them, yet I never received any of my pictures. Because if they didn't pass the censorship, I would have never been able to see them to be allowed to print them off.
Thank you.
Yeah.
Thank you. We're going to ask the department now to give their view of this issue.
Thank you. Mr. Wagner, Denmark Wagner, did file a facility claim regarding this incident. The facility claim response stated that the mailroom reviewed the printed pictures and they were deemed to be sexually explicit material. The response noted that Mr. Denmark Wagner had the opportunity to appeal that censorship decision or have the material mailed out of the facility. The censorship notices sent to him on February 18th indicated that the censored material was being held pending disposition and/or protest instructions. It advised that he could protest the censorship decision using a provided form on the reverse side of the notice, and that the material would be disposed of in accordance with regulation if no protest was received within 15 days. There is no record or allegation that Mr. Denmark Wagner filed a protest of the censorship decision. Moreover, the censorship did not deprive him of ownership of the printed material. He was not permitted to possess it inside the facility, but by regulation, he could have it mailed out of the facility. There's no indication that he made any effort to do so. Inmates own property at their own risk, and claims shall not be paid unless the damage or loss directly resulted from staff negligence. Mr. Denmark Wagner's claimed loss is not the direct result of staff negligence. He could have appealed the censorship decision or mailed the material out of the facility. Disposal of the material was the result of his failure to do either. And on that basis, we recommend that the claim be denied.
Thank you. Committee, do you have any questions for the claimant or staff? Very good. Thank you so much. That last claim that you were going to ask that we carry over, we need to read that into our minutes. It's claim number 7199.
Okay.
Travis Becker.
You just need me to make the request, yeah. This was one of maybe half a dozen claims that we received early in September, and I think we got most of them responded to, but this one was just the last of the bunch, and we couldn't quite get them all investigated and responded to for today. So we're asking that it be carried over.
Are they still on the line? Very good. Thank you.
So we can call the claimant if you'd like, ma'am, or we could, if the committee wants to consider carrying over.
Is the claimant waiting for us?
The claimant is waiting for us, but we can notify them. We can have another staff person call them and say that, and let them know it's being carried over.
Thank you.
Okay.
That would be good. Thank you very much. So at this point in time, we're going to take action on several claims, starting with 7181. And then we have 7182, 7193, 7195, 7194, 7196, and 7199. So I will begin with claim number 7181, Mr. Garcia, for $109.
Madam Chair, I move denial of claim number 7181.
Do I have a second? Representative Samsel, is there any discussion?
This particular claim was the one that I wrote down as racip. So this was the one with the MP3 player where he said it went in okay, and he said it came out bad. And I've never won a racipsa case in regular court either. So.
Very good. All those in favor of denying this claim signify by saying aye.
Aye.
Any opposed? Okay. Motion carries. Claim is denied. Claim number 7182.
Madam Chair, I move denial of claim number 7182. And as Senator pointed out, this was the one where the direct quote out of at least the written transcript was, "This isn't my property," or "This isn't my stuff." And so on that basis, there wouldn't be a claim for reimbursement. So move denial.
Is there a second? I think I'm going to go with Senator Straub on this one. Just to Is there any discussion? Okay. All those in favor signify by saying aye.
Aye.
Any opposed? Very good. Thank you. Motion passes. Claim is denied. Claim number 7193, Mr. Everson's first claim.
Madam Chair, I'm going to make a motion related to both 7193 and 7195, moving that those be carried over. I believe those were the ones where claimant had indicated that he had receipts, and I'd like for the department to be able to have a chance to look at those. So moving that we carry over both 7193 and 7195.
Second, Senator Haley. Any discussion? All those in favor signify by saying aye. Motion passes. Those two claims, 7193 and 7195, will be carried over. Next is claim number 7194.
Madam Chair, make the same motion in regard to claim number 7194 to carry that over to address some of the, what may be some inventory problems there.
Second, do I have a second? Representative Samsel. Any discussion? All those in favor signify by saying aye. Any opposed? Motion passes. That will be carried over. 7196.
Madam Chair, move to deny claim number 7196 in the amount of $8.
Second, Senator Straub. Any discussion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed? Motion carries. Claim number 7196 is denied. And then our last claim number 7199 that the staff recommends carrying over.
So moved. Chairman.
Is there a second? Senator Straub. All those in favor signify by saying aye.
Aye.
Any opposed? We will carry over claim number 7199. Thank you so much, committee. At this point, we will break for lunch. We take up again at 1:30, and we'll start with approving the minutes. Thank you so much.
Sometimes.
We'll be starting here in just a couple minutes. Committee, we are going to call ourselves back to order after a short recess for lunch. The first thing that we have on our agenda is to approve the minutes from July 22nd, 2021. They are in your packet, plus you would have received an email earlier, I think, or well, actually, I'll say later last night, if you had the chance to review that. So I would take a motion on the minutes, please. Representative Samuel. I have a motion to approve the minutes from July 22nd. Do I have a second? Senator Straub seconds. Is there any discussion? If not, all those in favor, please signify by saying aye. Thank you very much. Minutes are approved. So the first claim we have this afternoon is claim number 7201. It's a claim brought against the Kansas Department of Revenue by a company that believes they overpaid their sales tax. Unfortunately, we have a rule in our committee, it's rule number 6, and it says, no claim for tax refund for any tax paid to the state of Kansas shall be considered by the committee if a claim is not filed within 3 years from the date of the payment of the tax. And more than 3 years has passed. So we have to make some decisions here. Representative Ralph?
Thank you, Madam Chair. A couple of thoughts and maybe ending with a suggestion in regard to this particular item. I was not aware of, had not reviewed the agenda sufficient to realize that this issue was coming up, not generally familiar with the Rule 6 and its 3-year statute of limitations on this particular type of claim. Considering the fact that the committee hasn't, this particular committee hasn't fielded this type of a question before in terms of a claim that would ask us to waive one of our rules, in this case specifically rule number 6, a couple of things come to mind. One is maybe an opportunity for the committee to give some consideration to what the consequences of just that action in general might be. And 2 would be if we do that, what type of precedent we are setting. So I think my suggestion at this point in regard to this particular claim would be to carry this over without any action in regard to the request to waive the Rule 6. We carry it over to next time with the direction or instruction to the claimant that we'd like for them to initially make their case as to why we should consider waiving Rule 6 for them without looking at the underlying validity of the claim or amount or any of those things, just to determine whether in fact we want to address that procedurally and waiving Rule 6 to then go on to consider their claim for this overpayment of the sales tax. I'd be much more at ease to be able to know why they're asking us to waive that Rule 6, because it does appear to be a pretty significant request initially. So I'm not making a motion at the moment because others may have some comments or questions they may want to ask, but that's where I would lean, is toward a motion to carry over with the direction that the claimant next time not be prepared to talk about the merits of the claim, but to tell us why we want to waive, why we should consider waiving Rule number 6.
Okay. Committee, do you have any thoughts on this? Representative Miller?
And just to further augment what the representative said, I think they have or had a remedy for their claim, and that is an appeal / grievance to the State Board of Tax Appeals. And I don't know if they exercise that or not, but that's the way you go on these kinds of claims. Thank you.
Thank you. Any other thoughts? Considerations? Staff, did you have a consideration for us? Or additional information that you want us to consider? Sure.
Kind of equity, last resort,
Mhm.
so on. The rules can be changed. There's nothing that would prevent you, but if you want to follow the rule, then that certainly keeps you from hearing more.
Mm-hmm. Exactly. Any other thoughts for the committee? If not, then
Then, Madam Chair, I would make a motion that we carry over this claim to our next docket, along with a specific direction or instruction to the claimant that we will hear their case for requesting us to waive Rule 6 for consideration of their claim, that we would not undertake the merits of the claim itself, but next time we would listen for their, the justification for the request asking us to waive Rule 6.
the motion, is there a second? Representative Samsel, all those in favor, please signify by saying aye. Aye. Very good, then claim number 7201 will be carried over per those directions in our motion. Next, we'll move to claim number 7180. This is William Tyler. Mr. Tyler?
So, Madam Chair, this claimant submitted a claim, and on the claim itself, he did not provide a phone number or any contact information. When he was provided the notification of the hearing, the letter asked him to provide a phone number or email address. He did not provide that to the KLRD office. That may have been, I don't believe that that was communicated to the Department of Corrections. So the individual has not taken the onus to provide this information to contact. So the options before the committee is to either carry this item over, or we can read in a summary and you can hear from the agency and make a determination.
Committee, what is your desire for this claimant? We can take down his contact information or call back to get it, but let's hear the agency's response, even though the claimant's not present. Does that make sense?
So I can read a summary of the claim. I actually think one of our staff members, Malaysia, is on the WebEx. Malaysia, are you out there and are you prepared to read the summary?
Yes, Madam Chair, I am here. Give me just a second. I'm going to find the summary. Okay, I'm ready to read whenever you would
Thank
like.
you. You may begin. Please do.
Okay. Due to personal injury in the amount of $1.5 million is his claim. Claimant requests compensation of $1 million for the physical abuse administered by the correctional facility staff, extraordinary confinement, and lack of mental health care, as well as $500,000 for pain, suffering, and punitive damages related to incidents occurring on August 13th, 2019 and July 30th, 2020. This is William Tyler versus KDOC.
Thank you. Committee, if you don't have any questions of staff, we'll have a Department of Corrections give their side of this issue. Thank you, Libby.
And I reminded myself 7 times before coming up here, turn on the mic. Excuse me. He filed a federal lawsuit about this, and facility staffer confirms that
Somebody's trying to call us. Thank you, Libby. You may continue.
Mr. Tyler's federal lawsuit is still pending, so we're recommending that this be dismissed without prejudice pursuant to Rule 2.
Committee, any questions? Would you care to make a motion?
So moved on dismissal without prejudice pursuant to Rule 2.
Do I have a second? Senator Straub, second. And any discussion on this? If not, all those in favor, please signify by saying aye. Any opposed? Okay. Motion passed, dismissed without prejudice. Our next claim is claim number 7163. This is Mr. Todd. Property loss of $500. It's got to be a nicer way of saying that. I'm going to come back to that.
Yeah, Madam Chair, we can continue to try to get a better, or a phone number. If you want to proceed to the next one, we can work on that.
Sure. So the next claim number is 7178. We're a little bit early, but hopefully the claimant will be there. Do you want to go back to Todd, to Mr. Todd?
Mr. Terrell was ready.
Oh, that's true, Mr. Todd. He's ready. Yeah, let's go. That's a good point. Mr. Terrell. This is claim number 7197. Robert Terrell. He was on the phone earlier. Thank you for remembering that.
Sure.
Mr. Terrell,
Yes,
this is the Joint Committee on Claims Against the State.
yes.
Hi, Mr. Terrell. This is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the Legislature. The committee is hearing the
Yes.
appeal
Yes,
of your
sir.
claim, for personal injury that's been previously denied by the department, and it's in the amount of $37,916.62. So you are on speakerphone with the committee. The committee's been provided all the documentation of your claim for our review, including, you are on speakerphone with the committee, and we have all of your documentation. So we're going to ask you to tell us anything more you'd like us to know about your claim, and then we're going to ask the Department of Corrections to give the department's side of the issue. When that's completed, the committee is going to take some time to consider the claim, and then our written decision will be provided to you within 21 days from the date of this decision. Do you understand?
Yes, so far I have understood everything clearly.
Okay,
Thank you.
very good. Well, we are ready for you to tell us anything more you'd like us to know about your claim.
Well, before we go on, I had a question. Well, clearly my claim is dealing with what I feel was an unlawful and illegal incarceration due to a miscalculation in my complication, or SIMS complication, which was the responsibility of the Kansas Department of Corrections to compute after my journal entries were sent down there. And that's the heart of my argument. And if it would please you guys to bear with me because my voice is losing it. Just take a picture or something. Can you hear me okay? Hello? Hello?
Yeah, oh, yes, I'm sorry. Yes, we can hear you fine. It's a little.
Okay, I just want to make sure because I'm losing my voice.
Talk slowly, though. Would you talk slower?
Yes, sorry.
Thank you.
You got everything okay?
What was that?
Could you repeat that?
Do you have everything so far?
Yes, we're fine. We have all your documentation too, so mostly we just wanted you to let us know if there's anything more.
Well, clearly I think my claim that I filed with you guys is speaks for itself on its merits.
Okay, very good.
The only thing else I could add is that maybe under the expressio unius exclusionary alterius rule, nowhere in the Kansas statutes, nor the Kansas administrative regulations, such as the one he cited under KAR 44-6-140 subsection D, I believe, does it state that they have the discretionary power to go outside of using the term, which is the sentencing term, which is the months that I was sentenced to by the court. It seems like what they did was they computed each one after the journal entry came in, and they chose which one was the longer term after the computation. But that's not the way statutes or the law reads that I don't understand. It seems like the way they said it, only further solidifies the fact that I should have been serving the 40-month sentence, not 34-month sentence, because according to their response, in the Kansas Administrative Regulation 446140D that they cited was in the unity response.
Okay, thank you.
It's that the longest term of incarceration, if a concurrent sentence, and they also, I'd like to correct one thing. They said that my sentences were ran concurrent with that Sedgwick County case, but it's the total opposite. That case was ran concurrent to those cases, to the Winfield case.
Thank you, Mr. Terrell. We understand. We've got the written documentation here, and if you don't mind, we'd like to hear from the Department of Corrections now. Would that be okay?
Well, I do believe, yeah, that would be fine. Yeah, I think those were the, yes.
Okay, thank you. Hang on.
No, thank you.
Thank you. Mr. Terrell states that he was convicted and sentenced in Cowley County case 2018 CR 533 for aggravated escape, which was a severity level 5 offense, and in Sedgwick County case 2018 2853 for tampering with electronic monitoring equipment, which was a severity level 6 offense. In the Cowley County case, he was sentenced to 40 months with a sentence begins date of August 5, 2018. In the Sedgwick County case, he was sentenced to 34 months with a sentence begins date of 8/7/19. He argues that because the sentence in the Sedgwick County case was ordered to be served concurrently with the Cowley County case, it should be deemed to have begun on the same date of August 5, 2018, and the Cowley County case should control his sentencing guidelines release, or sentencing guidelines release date. KIR 447140D provides for new admissions with multiple concurrent guideline sentences, the prison portion of each sentence shall be added to the sentence begins date. The sentence with the term requiring the longest time to be served in prison shall be the sentence controlling the guidelines release date. If you add 40 months to the sentence begins date of 8/5/18 in the Cowley County case, that results in a latest guideline or latest release date of 12/5/21. Adding 34 months to the sentence begins date of 8/7 in the Sedgwick County case results in a latest release date of June 7/22. Under KAR 447140, because the Sedgwick County case requires the longest time to be served in prison, it is the controlling sentence. I guess I would note that the cases and statute that Mr. Terrell cites in his claim appear to address identifying the primary crime in a multiple convictions case, which is used to determine what the base sentence is and make sure that the overall sentence isn't more than double the base sentence and so forth, which is different from the controlling sentence in multiple cases, which is what this regulation governs.
And so the department is recommending that the...
I'm sorry, we were recommending that it be denied.
Thank you. Does the committee have any questions of the claimant or staff? Representative Miller?
I know it's in here, but I don't have time to go back and look. When was he released?
Fairly recently. I don't have that date in front of me. It was in August.
What document would it be on? Do we have that? Did you see it?
Does anybody have access to Casper from here? He may be able to tell you too. And the dates that I've cited, you won't necessarily match because they don't account for program credit and good time and things like that. These are latest guidelines release dates, and then you...
Right, but now I am really curious, based on what you just told us, that it was recently, because what I'm looking at here is the latest date of the two is June of 22.
Right.
And this is still 21, right?
Yes.
COVID and everything, I get lost.
Same. And I only think that it was recently. I'm kind of guessing.
I'd still be curious when he was released.
Madam Chair,
Yes.
Casper, which is the database of record on these, indicates a release date of September 17th, 2021.
Thank you. Thank you.
Committee, any other questions? Not, Mr. Terrell?
Yes.
Do
Yes.
you have anything else you wanted us to consider? Because we're going to close this hearing now.
Well, it was kind of hard for me to hear exactly what the other party was saying.
Mostly, we just
And,
asked a question about when you were released, and we were told it was September 17th of 2021.
But if that was, I heard somebody say something about the what were the controlling sentences, or which one would be the primary, or were they referencing to what I was arguing?
Right. Yes, that's correct. You did hear that.
They were referencing what I argued, or what?
Yes.
Oh, redundant. Okay, redundant. Okay. All right.
Thank you, Mr. Terrell.
Yes, you're welcome.
You will be advised of our decision. Thank you. Bye-bye.
Bye.
Do you want to go back and try Mr. Todd or? Okay.
Thank you for calling the El Dorado Correctional Facility. Please dial. There were no matches. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There have been too many failures. Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt. For visitation, press 3. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There have been too many failures. Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2. Please. There were no matches. Please dial the extension number. Press the star key to start over. We will now connect you. Sorry, the mailbox is full and there is not enough space to leave a message. To send a message, Thank you for calling the El Dorado Correctional Facility. If you know your, please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There have been too many failures.
It's not. Mr. Thomas? I'm going to try and dial 7178, Mr. Thomas.
Good afternoon, this is Shayla.
Hi, Ms. Smith. I'm Meredith with the Joint Committee on Special Claims Against the State. We are trying to reach Mr. Thomas. Is he available?
Yes, he is.
Okay.
Here he is. Go ahead.
This is Mr. Thomas.
Mr. Thomas, this is Senator Dietrich. I'm the chair of the Joint Committee on Special Claims in the Legislature. The committee is hearing the appeal of your claim, and the number is 7178. It's for $71.60 against the Lorna Correctional Mental Health Facility. So you're on
Correct.
speakerphone with the committee. The committee's,
Okay.
we've got all of the documentation for your claim for our review, including the description of your loss, and I'm going to give you the chance to tell us a little bit about that in just a minute. When you're done, we're going to ask the attorney for the Department of Corrections to give the department's side of the issue. And then when that's completed, the committee will take time to consider your claim, and our written decision will be provided to you within 21 days of the date of the decision. Do you understand?
Yes.
Very good. Well, this is your opportunity to tell us anything you'd like us to know about your claim.
Okay, well, when it happened, I was wearing my shoes all day. I got locked down at the end of the night and ended up getting removed from my cell on an altered state. It states all this in the paperwork. And the next day when they brought me my property, it wasn't on the inventory list. And I mentioned that to the officer, but still signed. And I've asked to get the cameras rewound to see what happened to them, if someone went in there and took them, or where they ended up being, because I never received them. And it was my only pair of shoes at the time. So that's why I kind of pushed it as far as I have, trying to get them back. But it's, from reading this paperwork, I understand that since I signed my inventory sheet, I basically don't have any chance.
Okay,
So,
Thank you, Mr. Thomas. We'll hear now from the state, and then if we have questions, we'll ask you in a few minutes, okay?
yeah.
Okay.
Thank
B,
you.
you may begin.
Thank you. Mr. Thomas's claim is that he was escorted from his cell due to being in an altered state. He received his property the following day and noticed that his Adidas shoes were missing and not listed on the inventory. The facility claim response stated that Mr. Thomas had been taken to the clinic, and staff who packed his property reported all property was removed and inventoried, and there were no Adidas shoes in the cell at the time. Facility staff responding to the present claim provided property inventories from the pack out, which is attached to our response. Mr. Thomas signed it certifying that it was accurate and that he had received all inventoried property on February 22nd, 2021. He signed for receipt of his property without noting anything missing, so his alleged loss can't be substantiated, and there's no showing that any such loss was the direct result of staff negligence. So we're recommending denial of the claim.
Thank you. Committee, do you have any questions? Representative Ralph?
Thank you, Chair. Libby, I think this is about the third one where I've noticed they use the term altered state. What are they describing?
Altered state of consciousness.
What are they describing?
Intoxicated or, for some reason behaving in a way that suggests some sort of altered state of consciousness.
Thank you.
Committee, any other questions for staff or the claimant? Oh, Representative Miller, I'm sorry.
Thank you, Madam Chair. I was trying to track these various signatures. One of these signatures that we claim he signed as to accuracy, was that done when he was supposedly in an altered state?
No, I don't believe so. I think they were both at the same time, was my impression.
Just to make sure I understood, I think I heard him say that when he received his property back, he called to their attention at that time that the shoes were missing. But then I also thought I heard you say that he signed an inventory sheet that said nothing was missing. Did I hear that correct?
That is correct.
And do you have anything to indicate that he did not just sign the sheet, but do anything at the time he got his property back to indicate the shoes were missing? All we have is the inventory sheet.
That's correct.
And he mentioned something about a camera and a record. Would there have been any recording of this event?
I don't know if that was explored. I don't think I investigated that with regard to this claim. Sometimes it's available, sometimes it's not.
Okay, thank you.
Committee, any other questions? If not, Mr. Thomas, is there anything more you want to say to us? Otherwise, we're going to close the hearing.
No, that's it. Thank you.
Thank you very much. Thanks for joining us today.
Yep.
Can you get us back to your?
Yes. Here she is.
Are we going to 7192 now?
Hello.
Ma'am, do you have Mr. Payton available?
Yep, are you ready for him?
Yes, this is claim number 7192.
Okay, thank you. Hold on just a second. Would you just let the officer know you're here? Thank you.
The department intends to request a carryover on that one if that moves things. On the one that's coming up at Peyton.
Mr. Payton.
Yeah. That's a claim that I didn't have
right.
until yesterday. I didn't
Hello?
realize I didn't have.
Mr.
Hello.
Payton. Mr. Payton.
Yeah.
This is
Uh-huh.
Senator Dietrich, Chair of the Claims Against the State. Your claim, we're going to request that that be carried over because more information needs to be found to give to the committee. Would that be okay with you if we carry that over?
Yes, ma'am. That would definitely be okay. Is it any way that I could, like amend my claim and add something to it? Because if you recall, when in this claim on December the 23rd, this hydro seal busted open in the transport van. They refused to stitch me up. Infection got in it. I went to a doctor's appointment last week, and I still have the same infection in my left testicle.
Okay.
This is almost a year now.
Sure.
Madam Chair, this is, the claimant could add material or amend the claim, but the material he adds should be germane or related to the original claim, which in hearing what he's referencing, it does sound like it is connected. It is additional material to the topic of the original claim, but that is up to the claimant to make sure that material is provided to this committee.
Did you hear that, Mr. Payton?
No, ma'am, I didn't hear it.
So you can add additional information to your claim as long as it's related to this original claim. And it sounds like
Okay.
what you're describing probably is a result of the original claim. So you can add to it. And that would then will give you time. We will roll this over into our next meeting, which is in November. So that gives you time.
Okay.
Representative
All
Miller?
right.
Would you ask him if it is related to the original claim or if he believes it's a new claim?
Mr.
I didn't, what did he say?
Mr. Payton, do you believe your current issue is related to the original claim or is it something new?
I'm more than certain that it is. Because I was rushed to the emergency room 3 times, and I was discharged all 3 times, and I was still bleeding profusely when I was admitted to the ER for that very reason. And then the last time, they refused to stitch me up, and infection got in there, and I've been in pain ever since that day. I went to a doctor's appointment last week, and it was discovered that I still have the very same infection in my left testicle that I did in January.
Okay, then I would agree. It probably sounds like it's related to your original claim. We'll give you some opportunity here to add to the claim, and that then also gives the Department of Corrections the opportunity to gather their material together. So we will move this to November, and we'll carry it over. Thank you, Mr. Payton.
Okay, thank you. You have a nice day.
Well, who will help him prepare the information?
That is up to the claimant, ma'am. They compile the claim and submit the claim themselves to the committee. If he's got additional, it's not uncommon that claimants submit amended material to the committee.
Thank you very much. And does that work then for the Department of Corrections?
Yes.
We'll carry that over. All right.
Thank you.
So we have left claim number 7198 and the original that we've been trying to reach, 7163. Where would you like to go? Third time? Third time. Okay. Good luck. We're going back to 71.
Thank you for calling the El Dorado Correctional Facility. If you know your party's extension, please press 2 and listen to the prompt. Please dial the extension number. Press the star key to start over. We will now connect you.
Hey, Adam 1, Unit Team Buchanan.
Hi, my name is Meredith with the Joint Committee on Special Claims against the State. We are trying to reach Mr. Todd. Is he available?
And we do have him available. I'll put you on speaker, or would you like the headset?
Speaker's fine.
Speaker's fine, okay. All right.
You don't? My bad. I said speaker.
Hello?
Mr. Todd? Mr. Todd?
Yes, how you doing?
Hi, this is Senator Dietrich. I'm Chair of the Joint Committee on Special Claims in the Legislature. So the committee is hearing your claim for a property loss of $500,000 or $500. I almost said $500,000. $500 against the Department of Corrections. So you're on speakerphone right now, and with the committee, we can hear you, and I hope you can hear us. We've been provided all the documentation for your claim for our review, including the description of the loss, and I'm going to give you the chance here in just a minute to tell us anything more about that claim you would like to tell us. When you're done, I'm going to ask the attorney from the Department of Corrections to present the department's side of the issue, and then when that's done, the committee is going to take some time to consider the claim, and we will get back to you with a written decision within 21 days of the decision. Do you understand?
Yes, thank you. I appreciate it.
Very good. So we're ready for you, Mr. Todd. You can describe anything that you want for us so we understand clearly what your claim is about.
Okay. 4416-102 states each inmate shall report every loss or damage to the inmate's own property immediately. I did that to my counselor, Mr. Smith. The B2 of that same 4416-102. The inmate could have discovered the loss and exercised reasonable effort to know the status of the inmate's own property and money. My only avenue to do that was through Mr. Smith, my unit team counselor, and I did that, and I followed his guidance to hold off on putting it in, and he put in a written statement telling y'all that he told me to hold up and let him investigate it. IMPP 1.1, the first page, says safeguarding and control of personal property. B2, each facility shall establish and maintain an area for the secure storage of each inmate's property, which is received, abandoned, or confiscated due to disciplinary or other administrative actions. The lawyer, Ms. Sanders, stated only part of KAR 4416-105. The full paragraph states, an inmate shall be deemed to own personal property at the inmate's own risk. Loss or damage of personal property shall not provide a base for recovery on a claim unless the loss or damage directly results from the intentional or negligent or act or omission of the correctional employee and was reported according to application internal management policy and procedure. Webster's negligent is carelessness. Omission is omitting. Omitting one, leaving out. Two, failure to do. Failure to make sure that my chain got to where it was supposed to get to. That's not on me. That's on them. She also states IMPP value limit, but failed to be upfront about how the value limit is not followed by KDOC. The same IMPP she quoted says rich watches are only supposed to be $25. Yet KDOC sells his rich watches for $50. The same IPP says shoe limit is 80. They sell the shoes and boots for more. Coolers, I could go on, but the point is made clear. In letting this. Hold on. I'm almost finished.
Okay.
And even if a mistake was made in letting my chain in that was overvalued, I have no power to make that mistake. You know what I'm saying? I can't approve my own property coming in or being confiscated. But I concede to the possibility of one being made. And the lieutenant who confiscated my chain and gave his statement telling that the reason he confiscated is because it was clear to him that it was overvalued. You know what I'm saying? It had a greater value than what we was allowed. And if the lieutenant is correcting a property officer's mistake of letting it in, you know what I'm saying? Which I never fought, never challenged. You know what I'm saying? He asked for it. I gave it to him. They made statements saying that I gave no resistance on giving it up. You know what I'm saying? But even the lieutenant's eye test leads credibility to the value leads credibility to the value of the chain being worth more than what they trying to say that the value limit is. That was the whole purpose of him confiscating it, you know what I'm saying? Because he said it wasn't supposed to come in, it was overvalued. He wanted to look into it to make sure it came in properly, and they verified all that. You know what I'm saying?
I do. We understand that. Thank you. Thank you, Mr. Todd. Can we hear now from the department?
Can I say one last thing?
Sure.
Real quick. The prison has substantial right to restrict the inmate's property of possession. You know what I'm saying? But once an inmate are afforded the opportunity to possess property, they enjoy a protected interest in that property that cannot be infringed on without due process. As well as the Fifth Amendment states, nor shall private property be taken for public use without just compensation. You know what I'm saying? And a solid gold man's chain with a crucifix, and to offer me a plastic chain for just compensation, that's not just compensation under nobody's eyes. To take a gold chain and offer me a plastic chain in replacement, that's not right.
Thank you.
But I don't want to go over time. I appreciate y'all listening.
Thank you, Mr. Todd. Appreciate the explanation. At this point, we'll listen to the Department of Corrections attorney. Libby, would you like to present the department side?
Thank you. Mr. Todd's claim is that he was taken to the clinic and his gold chain and crucifix were taken by staff who believed it was over the maximum allowed value. He filed a facility claim. The response noted that he had been moved to the infirmary and returned to general population with the next day. His claim was not filed until months later or until far outside of the time limit set forth, so it was denied. His facility claim was denied as out of time. With his present claim, Mr. Todd includes a letter from a unit team counselor, Scott Smith. Mr. Smith explains that he asked Mr. Todd to delay filing the claim to allow him to investigate. He says that he was able to confirm that a staff member did confiscate the necklace, believing it was in excess of the maximum allowed value, and turned it over to another staff member to be submitted to the Pastoral Care Department for further action. He was unable to identify the second staff member, and the necklace was not located in the Pastoral Care Department. Mr. Smith also states that Mr. Todd provided him with a DOC property receipt for the necklace, but that is not provided with Mr. Todd's present claim, nor does it appear that he submitted that with his facility claim. There is no documentation presented to establish the value of the necklace. IMPP 12120 provides that inmates are allowed to possess personal property in accordance with the specifications, quantity limits, and value limits set forth within the attachment to the policy. Attachment B permits possession of one religious medal or medallion with a chain valued up to $20. Section 4B of the policy states that inmates may not declare any property value in excess of the maximum established value limit. IMPP 118D provides that the department's liability for property loss or damage shall be determined in accordance with IMPP 12120D, taking into account the established value limit. Inmates own property at their own risk. He asserts without supporting documentation that the chain and crucifix was worth $500 and that he had staff approval for it. Even if he could establish this, the department's liability for its loss is expressly limited by policy to $20. Any additional risk was assumed by Mr. Todd. Therefore, we are recommending that the claim be approved in the amount of $20.
Thank you. Any questions? Representative Ralph?
Thank you, Madam Chair. Ms. Snyder, this one gives me pause. So that's the gist of my questions here, because I don't view this as a time concern in regard to his complaint there. But did I read in here that it was actually the chain or the necklace was confiscated from him because the officer thought it was obviously valued in excess of $50? Okay, so
The policy limit is actually 20.
I understand.
I'm sorry.
But that was the officer's, clearly by his description. So, Madam Chair, if I might ask a question of Mr. Todd. Mr. Todd, I'm not looking for a lot of explanation here. I want to know, can you give me any way to know what you paid for this or what the value of this necklace was? Do you have anything you can show me that is documentation or evidence that we could find in any fashion as to what the value of the necklace was that was taken from you?
It was paid for by a credit card from my family. You know what I'm saying? I can have my family get the credit card receipt as well as contact the jeweler that we bought it from and get all that if needed.
Okay, that's the only question I've got at this point. Thank you.
Thank you. Committee, other questions? Senator Haley and then Representative Humphreys.
Thank you. I'll defer to Representative Humphreys. My question really is for the department. So did I understand that you could have mailed it out or he could have sent the jewelry back to someone outside? Was that an option that was made to him?
I think that would have been something that the pastoral care department, it was intended that that would go to the pastoral care department to look at it, to investigate. Did it come through their office, which is supposed to, as a religious item? How much it cost, where did he get it, and so forth. Establish a value and see if it's allowed. If it wasn't allowed, then yes, he would have been allowed to mail it out of the facility, have it destroyed, have it donated. He would have options.
So why was that option not made then to him? I mean, if someone, from what we're understanding, if someone from outside purchased something for him, he was allowed, he did get it, it did come through, it had to come through. I'll make the assumption it had to come through. You had to see it coming in at some point.
I assume, one would assume, but it's, I mean, a necklace, I don't know. We don't have, nobody's investigated that because it never reached pastoral care as far as we know.
But you let it in, and it got in, and then it wasn't allowed to be sent back out. It just ended up destroyed, even though it was in excess of the value of the $20 threshold that you have.
Lost, I think.
Right.
Oops. Okay. Thank you. No more questions.
Representative Humphreys.
Thank you, Madam Chairman. I understand the time and, we've gotten something from Mr. Smith. I understand all of the statutes. So my question maybe is a little bit out of the purview of this committee, but it is concerning that a necklace that probably was worth $500 has just disappeared. And I just have to note that. I just have to let that be known that I'm troubled by that. That okay, we took it, can't remember who we gave it to.
Yes.
I do not approve of that. And I just have to let the committee know that. And it troubles me, especially when I just heard that what would have happened if it had gone to pastoral care is it would have been sent back to his family.
Potentially, yes.
Possibly. Thank you. Thank you, Madam Chair.
Or they could have determined that it was allowed in because it was within the value limit and not a $500
Yeah,
item.
but
I
it
don't
was-
know.
But something happened to it.
Right. Yes, and even if it was $20, it shouldn't have happened the way it did.
Representative Samsel.
Thank you, Madam Chair. Libby, on the flip side of that, is the purpose of the policy, is there a limitation on value of what they're supposed to have in there? Is that $50?
For a religious medallion and chain, maximum value $20 is what is allowed.
And I guess my concern is if we have multiple inmates in there worth medallions or emblems that are worth 500,000, well, is it part of for their own safety because we can't ensure what's going to happen with the property? I'm trying to understand the policy. I mean, this is an awful incident isolated. In the grander scheme of things, I'm trying to understand why that policy fits in so that we don't encounter multiple of these scenarios.
I am sure that's one of the considerations, and I have not been involved in any decisions about what maximum values to put on anything or anything like that. But I'm sure there are many reasons, and part of it being just, yes, security in the prison.
Okay, thank you, Libby. Thank you, Madam Chair.
Representative Ralph.
Yeah, Madam Chair, just one other bite. And just so, since we are streamed in such, I don't want the department to think that we're adverse to their policies and the limitations on the value of the $20 and those pieces. I can think of all sorts of reasons those are good ideas. This one causes me more concern because it's not an inmate saying, hey, I was out of my cell and somebody came in and took my really expensive stuff and you guys should have been protecting that. This one just lands with me different from the standpoint of we took that one single item as opposed to a box full of tennis shoes and hot plates. This one item. So that's another reason that I think you see the concern of the committee raised here. So I
do understand that.
I think where we're headed is to ask that this be carried over so that the inmate can provide that, because that obviously will be significant as well as what the documentation on the amount is.
Any other questions or thoughts? Representative Miller.
Thank you, Madam Chair. This is a good opportunity for me to belabor a point that I could have made any number of times, but this is a perfect instance, and I want to sort of go back to what Representative Humphreys was referencing. I used to hold a different position in a similar situation where, as a county commissioner, I saw similar claims by inmates. And the fact of the matter is, and it's a fact in the world, that there are improprieties everywhere, even for those that might be employed by us. And it does happen that money that is confiscated from inmates or people being checked into the facility disappears, because people are people everywhere, which is one of the reasons, Madam Chair, that I will sometimes take a different position than the majority of this committee, because I've seen things happen where I don't fault the department as an institution. I just recognize that there are human beings within the department that do things of imperfect individuals. So, that being said, we need to keep that in mind, that people who are incarcerated are not always the ones that are exaggerating the facts. Sometimes the facts are the facts and they don't look so good. This is a good example of what I'm saying, because it is clear that we confiscated an item of some value and it evaporated. And it did not evaporate through anything attributed to the inmate. Now, again, might have been completely accidental, but it might have been something very distasteful as well, because people are people everywhere, even if they hold positions of authority. We just need to keep that in mind as we try to sort through sometimes unsortable situations. Thank you for the time, Madam Chair. I thank the committee.
Thank you. Any other thoughts? I think at this point, we'll close this hearing and we'll move on to claim number 7198. Thank you all. Senator Haley.
Yes, is he?
Is he still on the line? We just hung up, I think.
Good, because if I could,
Okay.
Madam Chair.
Yes.
I wanted to, I guess, somewhat
Echo.
opine as to what Representative Miller, Representative Humphreys has said. I've sat on this committee a long time, and there is no doubt in my mind, I did not want to share that with our claimant, but with the members of the committee, that systematically items of value are being taken from within the system. I'll be a little more blunt than Representative Miller was. I believe in my heart of hearts that there are people that have access to inmates' property, personal property, and systematically it comes up missing. It is, these are the bad apples. I don't think it's systematic, but there are some within that. And why do I believe that? Because you will go through the manifest, Madam Chair and members, of the items that are missing. And systematically, they're the same items. And there should not or could not be a network between Hutchinson and El Dorado or the various Lansing. I mean, but it would just be those items that are. So I say all that to say, and thank you for the time. I've asked for several incarnations of changes, and Ms. Snyder knows that we should ask for a chain of custodies for the possessions, and that the department would implement that, to put the onus or the responsibility as custodians, not just of people, but of their items. And I've asked for that for, I don't know, 5 or 6 years on this committee, because it would cut out a whole lot of what we do in this committee. If we had that system in place, the checklist that puts the onus of responsibility for the care of valuable, whether it's a gold crucifix or certain televisions or MP3 players that come up missing in every manifest that we have. And I would hope that at some point in time, Madam Chair, with your leadership or someone else's, that we finally will get that request back from, I've also mentioned it to Secretary Zamuda and to Randy, that, you help us do this, help us do our job better here by clearing out all the chaff of the obvious cases, perhaps, where valuables come up missing. Thank you, Madam Chair.
Senator Haley, I think we're all in agreement that there's some process pieces here that could be handled better. Thank you. So our next claim is claim number 7198. This is Lansing Correctional Facility property loss 236.47. 236.
You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen to the prompts. Please dial the extension number. Press the star key to start over. We will now connect you.
This one's
Haley Knudsen.
Can't take your call now. You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen to the prompts. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. There were no matches. Please dial the extension number. Press the star key to start over. You have reached the Lansing Correctional Facility. If you know your party's extension, press 5 and listen. Please dial the extension number. Press the star key to start over. We will now connect you.
Haley Knudsen.
Can't take your call.
Madam Chair, we're having some problems reaching this last claimant. We can continue to try if the group wants to move on to voting. And
Let's do that. Yes, thank you. We will take motions on claim number 7163, 7178, 7192, 7197, and we're waiting on 7198. So 7163 to 7197. Do I have a motion for the first one?
Madam Chair, move to carry over claim number 7163 for Mr. Alan Todd, waiting on submission of additional documentation regarding value of the personal property involved.
Do I have a second? Senator Haley, second. Any discussion? Discussion?
Question.
Senator Miller?
Question as to process, will it be made clear to him to provide us with that documentation? I mean, we discussed it, but if this motion carries, will he be then directed to provide that?
I guess the purpose of I would assume so. The purpose of my motion would be, though, that unless and until he tells us he can't or we get it, I don't intend to vote on this until we get that information from him. But in whatever fashion that's communicated, that would be my intention.
It'd be pointless just to carry it over unless it's made clear to him that he needs to dig up. He referenced a credit card slip from a family member, which if he can provide it, that's good enough. As long as he understands that we are waiting on that so that we just don't spin our wheels.
I believe that he does because I clearly asked him twice. And you asked him if he.
We asked him if he had it.
Yes.
We didn't say anything about can you produce it?
Okay, so let's jump to the piece of in the notification of the hearing, let's include that he should submit that in advance of that.
I think I did verbalize that. We will carry this over if you can give us your receipt. So, but if we put that in the
I don't think
notification.
you did, but I may not have been listening close
Okay.
enough.
Well, then we've got the notification piece,
Thank
right?
you.
Okay.
yes, Madam Chair, we can include a sentence in there about providing additional information in the notification that is sent to the inmate.
Perfect. Second, or question?
A comment, if I may, Madam Chair. I have got two pieces of heartburn. We've had a few claims today. Broader picture, it seems like we're waiting on receipts from the claimants. My heartburn is the extra work it makes for staff to carry these things over. On this narrow one, I also have some heartburn that the inmate was in knowing violation of the limit. And while I don't like what happened, my concern is the precedent we set if we approve it more than the department's recommendation of $20, that is going to encourage other inmates as they discuss this situation to bring other valuable items of jewelry. So I've got some heartburn with that. That's my understanding of the department's recommendation of why they only recommended $20. So I just wanted to share that with the committee. But it sounds like I may be in the minority on that. So I just wanted to share that. Thank you.
Other discussion? Representative Miller and then Senator Haley.
Well, if I may respond, as Perry Mason would say, it assumes facts, not necessarily in evidence, that he knew he was in knowing violation. It got into his possession through somebody authorizing it. So we don't know that he knew it was in violation if someone didn't point out to him that it was. Someone may have sanctified it and therefore he had no idea he was violating a policy. There's no evidence he snuck it in. It sounds to me like a relative bought it, sent it to him, and it passed inspection. And how was he to know he was in violation at that point? Thank you.
Senator Haley?
And then the next step is, if in fact we're the custodians of something that is violative of our policy, we, the state, have I think, a duty to ensure that there's the opportunity to return it since we let it in. So the next step is whether he knew or not, if he was in violation, as Representative Miller said. But then since we, the state, allowed it or received it, it wasn't snuck in, if I can paraphrase the representative, then we have to we have to make some sort of provision. At least my opinion is we have a duty or responsibility to get it back. So thank you, Madam Chair. I just want.
So I have a motion and a second. We've had discussion. All those in favor, say aye. Any opposed? Okay, motion carries. We will carry that over, and we'll give him an opportunity to get his receipts into us. Claim number 7178.
Madam Chair, I move to deny claim number 7178.
Do I have a second? Representative Samsel, okay. Do we have any discussion on this? If not, all those in favor say aye.
Aye.
Any opposed? Okay, motion passes. The claim is denied. Claim number 7192.
Madam Chair, I move to carry over claim number 7192. We had the affirmative representation from the claimant that he intends to amend or add additional information to the current claim. And staff.
Do I have a second? Representative Samsel, any discussion? Not all those in favor, please signify by saying aye. Aye. Any opposed? Motion carries. We will carry that over. And then we have claim number 7197.
Madam Chair, I move to deny claim number 7197.
Do I have a second? Representative Samsel, any discussion on this one? Not? All those in favor, please signify by saying aye. Aye. Any opposed? Okay, motion carries. Claim is denied. 7198 is our next claim number.
So, ma'am, we have a staff member down in the basement trying to call these numbers while we're doing this, and she is unable to make contact with the team unit, with the unit team lead. We can continue to try, or we may just call it at this point, and members might consider it carrying over.
Committee, it's.
Madam Chairman, I know at least two of us have 3 o'clock commitments, so, but I don't want to keep everybody else from doing their.
Well, we need a quorum though, and I've got 3 that are leaving, so at 3.
I'd prefer to carry over.
Shall we carry this one over? Can I have a motion for that? 7198.
Madam Chair, I move to carry over claim number 7198. At this point in time, we've been unable to make contact with the claimant.
Do I have a second? Thank you, Senator Straub. Any discussion on that? All those in favor, please signify by saying aye. Thank you all. We're going to adjourn the committee, but as I adjourn you, I want to remind you our next meeting will be November 18th, and that's likely to be a 9 o'clock to 4 o'clock because we've carried over so many. So I appreciate you being here today. Thank you for the great discussion, and look forward to seeing you again. Thank you. Meeting adjourned.